cultivate my own land, state authorities are not allowing me. My lord, these strangers who are here, in view of the Honorable Supreme Court order, they have been removed, but that
it been allotted, my lord. So, my lord, any day it will be allotted, my lord, and it will be infructuous, my lord. The license has been granted, my lord, illegally, my lord.
Notice?
My lord, I have given the notice, and it has been, my lord, mentioned also, my lord. Kindly, my lord, kindly take up the matter, my lord, tomorrow.
Tomorrow.
Let it be at the top, my lord, so that the matter can be taken. It's very urgent, my lord.
Yesterday I mentioned 2 matters. Your lordship was pleased to allow my prayer, but I made a delay in supplying the list.
Give the number. Give the number.
My lord,
What is your urgency, sir? Give the number.
my lord, unauthorized, my lord, construction over the PWD done in front of our.
Give the number. Give the number.
Application
Contempt. Contempt. Give the number.
Application, my lord. My lord, the matter of application, actually the petitioner has obtained the property from inheritance basis, my lord, but it has been recorded in the name of his deceased father, my lord. Further, it has been after a few years from a reliable sources came to know that the land has been vested by the state of West Bengal. Further, when he went to the BLRO office, it found that the land has been mutated in the name of the other land grabbers, my lord. Petitioner is suffering a lot, my lord. Kindly updated the
You're
matter.
asking for correction of record of rights.
No, my lord, we have already sent, my lord. It has been in the upgradation for upgradation.
What is your prayer? You're asking for correction of record of rights, isn't it?
Yes, ma'am.
So this court
No,
doesn't
no,
have
my lord. No,
jurisdiction.
no, it's not correction of record of rights, my
Then?
lord. Actually, the prayer is that, my lord, for upgradation, my lord, kindly,
What is the prayer? What are you asking for in the writ petition?
my lord, just a minute, my lord.
My lord, allow.
My lord, may I permit it to mention?
I'm dealing with one matter, madam. Please have some patience.
My lord, the prayer is that is that the commending the respondent authority each of their agents to withdraw, watch, and terminate. There's a purported LA case also been pending, my lord. LA case of 4/8 of 1994-1995 pertaining to the landed properties to the petitioner describes in the body of the writ petition and also direct the release forthwith the landed properties to the petitioner describes in the body of the writ petition from the purported landed acquisition proceeding, my lord.
Acquisition proceeding.
Yes, my lord.
Give the number. Restoration, give the number.
My lord, I'm mentioning one matter, item number 5. My matter, my lord,
Extension of interim order.
the
Extension of
kindly
interim order.
by taking,
Aajkal is
50.
50. Let me see if I can reach.
If
My lord.
matter is not taken up, my lord, kindly fix the matter at 2 PM.
এটা রাখুন যদি না হয় তাহলে কালকে রাখুন for extension of interim order আজকে যদি হ্যাঁ হ্যাঁ to be mentioned extension of interim order কালকে
the
The
kindly
private respondent constructed by taking the fund from the Indra Awas Yojana in front of my land. My lord. My entire interest access, my lord, stop, my lord.
give the number.
the kind leave, my lord, item number 723 of your lordship list, my lord. This is the second round of litigation, my lord. Lordship directed the ADM, my lord, to demarcate my land which has not been acquired. Now at the time of demarcation, my lord, they could not find the land, my lord. Now they are coming with the proposal that there is already this land has been acquired. My lord, we already my lord, required that show us the, my lord, payment that has been made. They could not show any scrap of paper, my lord. But this is very urgent, my
The
lord.
number. Give
Well,
the
item number
number. Permitted to mention one extension of interim order. When is it expired? Expired on 28th. But lordship, as per your lordship direction, matter to appear in the list today. But matter is not in the list. Give the number.
Lordship, if I can mention one matter, lordship, on last occasion, lordship was pleased to fix the matter on 8th May, but somehow the matter did not come up in the list. And lordship, this is a hearing matter. Hearing has already been done.
It's a hearing matter.
Hearing matter.
Yes.
Kindly list.
Group 1 hearing.
Group 1 hearing, lordship.
My lord, may I mention one matter, my lord? Several matters disposed of by your lordship's own judgment. I am also the same footings, my lord.
What is the matter about?
Matter about land acquisition.
Give the number.
May I, your lordship, I leave to mention item number 948 of lordship. What happened is the matter of land and land. I have prepared the land
The certificate has been withheld by the district magistrate. What that with respect to getting service in government school, but I arranged for.
Give them.
May I have a lordship kind?
Group 8 matter, the one you were mentioning yesterday. You've put the other side on.
My lord, there is an
notice?
inclusion the matter, my lord. My lord, inclusion the matter in the.
What is your urgency?
My lord, it has the affidavit have already been completed, my lord. The KMDA has already filed the
It's a
opposition.
hearing matter.
Yes, my lord.
Affidavits are complete.
Yes, yes, my lord.
Hearing.
May I have a lordship kind leave to mention one monthly list matter, my lord, for inclusion, my lord, for upgradation in the daily list, my lord. My lord, the urgency is that the tenancy has been expired in 2012. But still other side is enjoying the property, my lord. The point of law has already been settled by the Supreme Court, and moreover, my lord, the point of law already been settled by your lordship by a judgment dated 26th April 2023, my
Give
lord.
the number. Give the number.
Let this matter, my lord, appear any day subject to your.
They have initiated a mistake for recovery of the money. By matter will be.
It's a group 3 matter. Certificate proceeding has been initiated, you say.
For recovery of money from conversion from wetland to.
Does this court have jurisdiction? Give the number, let me see. Give the number, let me see.
Lord, may I have a lordship leave to mention on matter for upgradation? Because pursuant to your lordship direction, executive engineer decided that land has been enclosed by the private respondent. Private respondent filed this petition without preferring appeal, only to stall the proceeding under section 10(3). Well, SDO could not proceed with the matter since the matter is pending before the lordship.
You are the respondent in this matter.
In this matter, I am the respondent.
Have you put the other side on notice?
No,
Put the other side on notice. Because you are the respondent.
lordship.
Yes.
Hello, now today's item number,
Sufficient mentioning has been taken today.
item 57, my lord. Today's item 57, my lord.
Days lease do not mention.
Not this week,
Yes.
I'm praying not this week, my lord.
Well, let it be called, sir.
Okay.
This matter was filed to March of March. My lord, it is continuing in the list, your lordship's list, my lord, it is not starts at all. My lord, when the matter was filed, my lord, at that time, point of time, the English and English is blocked. My lord, now it is completed. My lord, kindly take up this matter. my lord.
Now it is?
Now it is completed. Their structure is completed.
It is in the supplementary list.
No, my lord, it is
Monthly list, give the number.
May I be permitted to mention item number 506 of the monthly. Lordship, issuance of the land certificate. The Honorable Division Bench, Lordship, upheld the order of subsequently Honorable Supreme Court also. Lordship, upheld the order of issuance of this same identical order.
Give the number. Give the number.
My lord, may I have your lordship's kind leave, my lord, to mention urgent group 8 matter, my lord. We are filing the writ petition. We will give the number to my lord's officer.
Monday, the bench is joining.
My lord, may I indicate the urgency here? I'm a jute mill, my lord. I'm entitled to receive production control and supply order as issued by the Jute Commission. That is the only source of sustenance of a jute mill. I have 3,000 employees, my lord. Repeated representation. My predecessor used to get the PCA but thereafter, pursuant to an agreement, I have now taken control over the jute mill and the name has changed. I've applied, my lord, for the change of name to the Jute Commissioner, my lord. Documents submitted pursuant to the letter of the Jute Commissioner. Thereafter, complete silence from the Jute Commissioner.
Wait till Monday.
But 3,000
Two more
workmen.
working days, it can wait.
Very well, my lord. If I may give the number, can my lord direct the matter to appear on Monday? That can, if
That can be done.
very well, my lord. May there be
Silence.
some precedence on the Monday. We'll give the number. I'm grateful, my lord.
Lordship, may I permit to mention under heading upgradations in item number 976 in the monthly. Lordship, that in this matter, during the pendency of this writ petitions, the private respondent tried to possession of the land of the petitioner. And in this such situation, if a complaint has been written, complaint has been launched against the petitioner, and if has been launched against the petitioner at Gulchi PS2 station. So she kindly take in this matter.
How does this court have determination?
Yes, Lordship.
What is the land issue in this matter?
Land-
You say FIR has been lodged.
Yes, Lordship. Lordship, that in this matter, dispute is arising between the petitioner and private respondent about the land. Private respondent taking possession.
Petitioner and private respondent. So how is the writ petition maintainable, madam?
Lordship, this, ma'am.
The state is not involved.
Yes, involved, Lordship.
Give the number, let me see. Give the number. Yes, call the days list, please.
Lord, I am for the petitioner, my lord. My lord, in order expire, my lord, Friday, my lord.
Who is appearing for the? You are appearing for the state?
Hey,
Affidavits complete?
no, my lord. Lordship kindly,
Affidavits?
no. There is no direction. My lord, last occasion I prayed before your lordship, my lord, let them file an affidavit. আরে বাবা তুমি আমাকে কপি দিয়েছো কপি কপিটা তো খুঁজে পাচ্ছি না তাহলে আমি দিয়ে দেবো
Have you served the railways?
yes my lord appeared they
No, no, today you are moving the
no
extension.
no my lord
In absence of the railways, I will not allow you an extension.
এটা কপি দিয়ে দিও
You have to put the other side on notice. You are asking for an
my lord
extension
lordship
of
keep it
interim order.
tomorrow my lord I shall
Not today, not
my
today.
lord my lord
Please
my lord.
serve and come back.
আচ্ছা এটা কপি দিয়ে দিও তাহলে আমি বলে দেবো কি
Not today.
গেল তো আইটেম নাম্বার 2 আছে হ্যাঁ জানি
My lord, item number 2, my lord, the petitioner is instructed to withdraw the matter with liberty to file afresh. My lord, certain documents have not been annexed, my lord.
That can be done by way of a supplementary affidavit, right?
My lord, the petitioner is instructed us to go afresh, my lord. Kindly,
What is the ground? It is, it cannot be the liberty of the petitioner.
yes, my lord. My lord,
If it
what?
is only documents, there is no question of withdrawal. I will not grant fresh liberty.
Yes, my lord,
You
but
can, of course, withdraw your, it is your case, you can withdraw.
yes, but my lord.
If it's only documents, you can come up with a supplementary.
And
affidavit.
my lord, what happens is a change brief. There is some more part we have to add in the writ petition, my lord. That is the difficulty. That is why, my lord.
Who is appearing for the?
My lord, my senior friend is appearing, my lord.
চাচ্ছ কি তুমি আগে একটা চেঞ্জ করেছি তো ওরা হচ্ছে নতুন করে ফাইল লিবার্টি টু ফাইল
I'm grateful, my lord. My lord, may the instruction be.
Learned counsel for the petitioner submits that the petitioner seeks to withdraw the writ petition
আগের দিন কবে হচ্ছে
on account of certain defects detected therein and seeks further liberty to file a fresh writ petition on the same cause of action. Paragraph written instructions submitted on behalf of the petitioner is taken on record. Paragraph in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Liberty is granted to the petitioner to file a fresh writ petition on the same cause of action.
I'm grateful.
Paragraph, there shall however be no order as to costs, urgent certified website copy.
I am appearing on behalf of the petitioner, my
My lord, I beg to appear on behalf of the alleged contender, my lord. On 10th, my lord, it could not, my lord, appeared, my lord. There was some mistake, my lord. It was placed before the district magistrate on 10th. The day on which, my lord, the matter was heard. Actually,
Yes.
my lord, it was delivered to the through post office on 6th. But there was a mistake on the part of the, my lord. The order, my lord, I am praying some time for compliance, and my lord, all the annexures are not along with the petition, my lord,
There is the show cause.
my lord.
There was a direction for show cause as to why rule of contempt shall not. be
Yes,
issued.
my lord, my lord.
So if there is no show cause, rule will be issued today.
My lord, I shall file the show cause, my lord, because my lord.
Today it was supposed to be before the court today. This is a contempt application, sir.
My lord,
Where is the show cause? Otherwise, I'll issue rule, take necessary steps.
my lord, if your lordship, my lord, kindly give me 1 week time, my lord, I will give the show cause, my lord. 1 week time.
The order passed on May 10, 2023 has not been complied with. Paragraph, the alleged contemner is directed to personally appear before this court and submit a show cause as to why. Submit and show cause as to why rule of contempt shall not be issued against him for non-compliance of the order of the court. paragraph, let the matter appear under the same heading.
Personal appearance টা ইয়ে করতে হবে।
My lord, is there any direction for personal appearance?
Yes,
My lord, is there any direction for personal appearance?
absolutely. Today the show cause was supposed to be here in court. Where is it? He has not even bothered to file a show cause.
Not করে সোমবারই রাখো।
My lord,
There is a limit to disobedience. It's 20th June, 20th June.
I beg to appear on the petitioner. Your lordship's direction, my lord, I have tried to serve upon the, my lord, private respondent at 4 addresses. My lord, he lost caveat, he filed 144 application in different addresses has been mentioned in different applications. I served, my lord, everywhere. Lordship kindly have a look, my lord. Intentionally, my lord, avoided very peculiar issue, my lord, has arisen in this case. Very peculiar issue. In all the 4 addresses, my lord, I have served. Send those, my lord.
What is the endorsement? It has returned with no endorsement. What is the endorsement?
That is my no endorsement.
There should be some endorsement.
এগুলো তো লিখিয়ে রাখবে কি এন্ডোর্সমেন্ট এসছে না সবই আমাকে দেখতে একদম মুশকিল হয়ে যায়। Lordship can be able to look to the caveat lodged by the private respondent. At that address I was sent. My lord, file 107 application. At that address, my lord, I sent. My lord, file 144 application. At that address, my lord, I sent. But nowhere, my lord, he received that, my lord, service.
And there is also no endorsement that he has refused. That is also not there.
Well, not refused, not sufficient, the address, nothing, my lord, has been written, my lord.
File an application for substituted service in that case. We have to exhaust the provision.
Because, my lord, his presence is required
That's why file an application for substituted service.
for
45
publishing,
rule 20.
for publishing newspaper. Very difficult, my lord, intentionally, my lord, he is avoiding to accept the service because
Issues raised entirely below relates to private.
no, my lord, what happened in this case? My lord, I have got one property that is another premises number. He is claiming in his application, my lord, another premises number. But very strange enough, my lord, he is identifying as if that, if I say, no, this is not the Honorable High Court, this is the Supreme Court. And my lord, the corporation and KIT, my lord, verified, inspected the premises, my premises. My lord, sanctioned the building plan. Still, my lord, he is one after filing 107 application.
It's a private dispute essentially.
But I cannot identify because KIT, my lord, KIT is the authority who can identify the property because it was within the, my lord, KIT.
So for that, does a petition lie?
My lord, the authority, my lord, is, my lord, obliged to, my lord, to identify the premises, my lord. I am not claiming any civil right. I am not.
Have you applied before the authority?
Yes. Well, I am not claiming any civil right because there is no dispute. His property is at another DAG number, my property is another DAG number.
No allegation against the public bodies.
But that is
No
all.
public element in the writ petition.
No,
so-
only for proper identification because, my lord, at the time of sanction of the building plan, it is the, my lord, practice, my lord, the KIT authority and the KMC authority, where there is a survey, my lord, they have conducted. And on the basis of the survey, my lord, they have prepared a plan showing my address. So I am, my lord, praying, let, my lord, a joint survey be held in presence of all the parties. But in that event, my lord, what is my property, what is their property?
Complete service and come back.
No private claim, my lord, no private dispute is there,
So I am just adjourning the matter. I am giving you some time.
my lord.
You have to file an application for substituted service.
Well, within 1 week, I can file this application, my lord, because order is there required to, my lord.
When you file the application, mention the matter, it will come up under application.
My lord, my lord.
An attempt to collect evidence.
That is not no collect evidence, my lord. If that is so, then how can I?
Service upon the
enter a
private
civil suit?
respondent
If
is
that
not
is so,
complete,
then order 26 rule
comma,
9
let
is
the
not
matter
applicable.
stand over till
Order 13 and rule 7 is not
3rd
applicable.
July. In the meantime, file your application, it will be considered.
Oh, my lord, 3rd July, I have got some personal.
Fourth.
Fourth. 7th. After 7th, my lord.
After 7th, so 10th, 10th July.
I beg to appear on behalf of the petitioner. My lord, this application,
State respondent.
application, my lord, relates to my lord
6 or 7.
5.
7 also. 7 না তো 5 and 6 কার তোমার
6 someone.
6 আমি
Item 5. Yes.
ও আচ্ছা ঠিক আছে আমি 5 এ আছি তোমার সব আছে এসো 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 ভাই এসো এসো
Short term 5. 5.
Blood, I have already submitted my report in respect of item number 5 and that has been kept on record.
আমরা দিচ্ছি দেখ
Have you received a copy?
No.
Because you chose not to appear on the earlier.
last occasion it turned up. 13th of April was the last date perhaps.
How do you expect a copy?
My lord,
Please
kindly,
give him a copy.
can you give and fix any date, my lord, subject to lordship? Can you give me a copy
In course
that
of
I
the
can
day,
take instance?
to get it.
Kindly fix a date, my lord, I need it. Tomorrow?
5
Tomorrow?
and 5 and 6 may be taken together as your.
5 and 6 are running analogously.
Blood, I will give it in course of the.
Copy of the report submitted on behalf of the state respondents be served upon learned counsel for the petitioner in course of this day. Paragraph on prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 29th June.
Grateful to.
29th,
7th is also similar.
29 June, my lord.
29th.
7th is similar.
7 was
Sir,
similar.
7th also similar, my lord.
দেখে নাও
হ্যাঁ আমারই মামলা সব short.
7, you have submitted the report.
No.
7
No,
কি
the
আছে
report submit করেছি?
Who is appearing for the state? You are appearing in
I'm
7
appearing.
also. 7,
রিপোর্টটা কবে দেবেন?
5 and 6 action.
রিপোর্টটা আসেনি
7.
এখন।
নিজের আসবে না টাইমে এখন রিপোর্ট
রিপোর্ট এনেছিস? আমরা কোনো রিপোর্ট ফাইল করেছি? রিপোর্ট করে আমি এনেছি পিকচার।
This is appearing for the first time.
Yes, my lord.
Yes, make your submission. Is it the same issue?
Yes, my lord. Regarding the short term issue, my lord, I have applied there with requisite fees, my lord. I am paying for only consideration of my short term.
Same, 5, 6 and 7 same.
You are praying for consideration of?
Only consideration, my lord. Page 18, my lord, I have applied in for.
Blood, let me, blood, I haven't got the report also, blood, let me come back with the report, my junior friend, you already requested for the report. আরে বাবা দাঁড়াও রিপোর্টটা তো দেখতে হবে
Consideration.
না দেখে কনসিডারেশন কি করে করবে আগে দেখি কি দেয়
You need the report for consideration also?
let me see just browse
Only, my lord, I am paying for consideration.
department your lordship has saved me
My
Without
sir
the
is
report,
very
how you
tough.
have said?
That is very tough.
So.
I am not tough I am
Very
not
tough.
I am very
On
much
prayer of the
accommodating
state respondents,
why not
let it be adjourned on your
Eh,
prayer.
Respondent number 6, my lord. This call.
আরে 29 June you can keep it all the minutes can be taken together
On prayer of the state respondents, the matter is adjourned. Let the matter appear under the
বলো
same
না
heading on 29th June, same.
সার্ভিস এই আপনি এত ভালো লোক চাপ বলো কেন গো?
জুনিয়রদেরও দেখেন না আপনি কি করছেন?
তোমাকে সবসময় বাই বাই 29
Next,
আচ্ছা 29 হ্যাঁ
affidavit of service. Vashu, affidavit of service. Yes, item number 8. No one. None appears for the petitioner. No accommodation is sought. Let the matter appear under the same heading on 12th July. Any love?
I'm for the petitioner, my lord. I saw all the respondents are affected, my lord.
I beg to appear, my lord, on behalf of the private respondent. 8, my lord.
State, your appearance? Yes,
My
what's
lord,
the
on
matter?
on the unauthorized construction over the PWD land, my lord. The petitioner made representation that may be considered by the authority concerned, my lord.
Private respondent?
But I saw my undertaking.
My lord, kindly come to page 33, my lord. From my take, my lord, I find
You are appearing for the private respondent?
page 33, whichever, what is the representation, that is the representation. In my take, my lord, I find there is no signature of the petitioner, which has been served to the, allegedly served to the authority, my lord. Page 33, my
This is
lord.
because this is a copy.
My lord, this is a copy of the
The original is served.
signed copy of.
I don't know, my lord.
Copy may not have a,
In my
copy may not have a signature. The original is
That is
served.
true, my lord.
My lord,
Correctly, sir.
That, as I am told, my lord, I am not in PWD land. It is some portion of the private petitioner's land and in some portion is house land, government land. My lord, kindly appreciate if there is a provision in West Bengal Land Force Manual. My lord, even if, my lord, it is found that the some unauthorized occupant is occupying it.
This is the 64 Act, 1964 Act.
No, my lord, it is Land Force Manual. It says, my lord, 238. Kindly have a look. It has to deal with.
My specific case is this, my lord. I am alleging the objection as per West Bengal Highways Act 1964, my lord.
Yes, 238.
Left and top one. Settlement with unauthorized occupants. The land used for non-agricultural purpose. Yeah, my lord, I am residing there. I will endless people. But I have no land in West Bengal anywhere. Purpose are often found to have been in possession of persons for a long period without any lease. If the
Have you applied?
my lord, let me complete. Even I do not apply. I did not apply, my lord. The provision says, my lord, may I read, my lord. If the period of possession in any such cases exceeds 12 years, admittedly, I am residing, my lord, before more than 12 years, since 1993, my lord, 92. The 12 years, the person in possession, if agreeable, may be offered long-term settlement. I am agree, my lord. If not, he may be permitted to remain on payment of fair and equitable rent regard being had this section 11 and 12 of the West Bengal Non-Agriculture Tenancy Act 1949. But if he has used the land in a manner which renders it unfit for use for the purpose of tenancy, steps should be taken to eject him by a suit. Where the period does not exist 12 years, the tenant may be offered long-term settlement in accordance with the preceding suits. If it is necessary action to be taken at once for his settlement in the manner indicated above. Each case should, however, be carefully examined before any suit for settlement in this.
How is this applicable? This is a PWD road.
No, my lord, it is not a PWD road. This is my specific instruction, and it is khas land, government land, and even if it is PWD road, it belongs to government. And government land,
Quite different.
and government land, it says, my lord, whenever it is in occupation of some unauthorized occupants, being the, my lord, poor landless people, if is, it says, my lord, 12 years. Even if it is less than 12 years, if it is, my lord, thereafter, my lord, it says, my lord, if it is not Paka structure. I am not, admittedly, it is not a Paka structure. Although he has alleged it is Paka structure.
And it is all may. It is the discretion of the government.
Yes, may. But it says, my lord, before that, the government, if language in such a fashion it has been used, my lord. First, he has to approach, he has to ask by the government that whether you are agree to take long-term lease. If it is not, thereafter, then it indicates some protection has been given by the statute, by the to the illegal occupants, more particularly the landless people, who is in non-agricultural purpose. That is, my lord, for residential or other purpose. That protection is.
Well, this may be applicable to the 1962 Act, not to the the 1964 Act. It is a self-contained act, the West Bengal Highways Act 1964, and there is a specific provision in the act under section 8 most probably, where you can regularize your unauthorized occupation. You have not done so. Please come to the Act of 1964.
At all applicable in this particular case, madam. My understanding is referring the manual of the West Bengal Land Reforms Act. At all applicable in this particular case. This is the West Bengal Highways Act 1964. And on that very particular date, when the
Does not say the land belong to
no, that's not.
other government.
On
It is
the-
government land.
Yes, yes. The
It is
separate department.
PWD land,
Yes,
well,
separate.
it is
No.
also the government land.
No, it is a separate department, quite different department. Several cases are before this honorable court on the departmental, there, my lord.
So
Land
this
owned by
has
the-
to be considered.
No, not at
If
all.
my lord directs to consider, my lord, this particular provision has to be considered.
That application
Because-
are not at all
My
applicable.
lord,
You will have the liberty to make this submission before the authority. But then prima facie, I am of the view that this is not applicable in this case.
my lord, it
No,
says.
Have
my
to
lord,
go by the 1964 Act.
Yes, I am on 1964 Highway Act, but it says on the government road, it says, my lord, any government
It
road.
is separate department, quite different department.
It does not, my lord,
Does not make
discriminate
the
or
alert department.
separate. Provision 238 does not, my lord, separate or discriminate any other government. It says, my lord, unauthorized document in the government.
This is a
Government.
manual
That
which
is
is
alert
in
department.
support of the Land Reforms Act.
Land department, alert department.
This is a manual that you are pointing out.
And my
Alert
lord,
A
department.
manual is not a law by itself.
no, it is not, it is guideline. It is guideline. Whenever the guideline has been.
So what is the law which has, I mean, the manual follows the law, isn't it?
Yes.
So that is the Land Reforms Act, which is not applicable here at all.
Not
I'm
at
sorry.
Well, not at all applicable.
Before that, my lord, whether it would be, my lord, maybe the government can grant me long-term lease before my lord evicting me.
Not in
Or-
case of a PWD road.
Not necessary.
And not only that, my lord, he complains, my lord, his ingress and egress. Lord,
That is immaterial.
that is another.
That is
aspect.
immaterial.
That is another aspect. But when, my lord, since 1993,
I think I will not go into merits. Let the authority decide, because if I go into merits, it will not inure to your favor, sir. You will face more difficulty before the authority if the court decides. So I think it is better that the authority
I
decides.
will be granted liberty to raise. all this.
Absolutely.
I'll kindly
Absolutely.
report.
You will be heard before it is decided.
Raise all the points.
Because if it is decided on merits by the court, then the private respondent will be left with no option.
Not at all applicable.
Sometimes, my lord, I have
Not
to
at all
appear
applicable.
on that side also.
No, not at all applicable in this particular. case.
Affidavit of service.
My lord, kindly record one thing, my lord, we have no paka structure and we are landless people. Kindly record that. And since
The
1990,
petitioner claims to be the recorded owner of the plot in question and complains that the private respondent has raised unauthorized construction by encroaching upon a portion of the PWD road adjoining his plot, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation in this regard before the concerned authority on
On my road.
5th December 2022, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the private respondent that the private respondent is a landless person and has not constructed any paka structure on government land. On government land. That is your submission. Paragraph. Learned counsel for the state
and my lord,
respondents.
that portion, whichever that is, maybe government, may not be government, I do not know, my lord. We are staying,
Objection may be raised before the authority.
we are staying there, my lord, since 1992, my lord. Kindly record.
ওখানে add করুন. The private respondent has been residing in the
No, আমার কাগজ আছে।
said land since 1992. 1992.
19, yes, I have that.
Paragraph. It is submitted on behalf of the state respondents that the third respondent
Yes,
be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, comma, in accordance with law. Disposed of. Please take back your book.
Place in different way.
New case.
Try your luck before the authority. Next.
My lord, I am for the Union of India.
My lord, item 10 appearing on behalf of the petitioner, my lord. It is for the matter. My lord, this is my affidavit of service. Upon all, my lord. My lord, this is the case of encroachment of national highways land, my lord.
It's appearing for the Union of India. Union of India, you are appearing?
I am for the Union of India, my lord.
And the private respondent?
My lord, served up.
Served?
Yes, my lord.
My lord, in the cost title, my lord, they suppose lordship the private respondent number 8, but in the synopsis, my lord, he mentioned private respondent number 9. My lord, whether he's forget to add another respondent or whether
No, my lord. This is typographical mistake, my lord.
Okay, okay,
Private respondent 9.
Respondent number 8.
হ্যাঁ না হতে
But
পারে
in
সেটা
the
হ্যাঁ সেটা হতে পারে নাই হলে হয়তো আমাকে
page 3, my lord, I mentioned respondent number 8, my lord.
It is 8 according to the cost title.
Yes, my lord. By encroaching the national highways land, my lord, they constructed the illegal construction, my lord, and affected my ingress and egress, entirely blocked my front position, my lord. So respondent number 2 is the authority. I given the representation, page number 37, my lord.
The project director will consider.
Yes, my lord.
My lord,
Director
in
P2.
this matter, my lord, I am not in a position to give you any idea, lordship, because whether it is a national highways land, lordship, it is a land of the NHPWD division, lordship.
Come back with
So
instruction.
with this type of instruction, lordship, yeah, otherwise, if a lordship can dispose of this representations, lordship, because I don't know whether the project director is as well as lordship the answering.
Who will dispose of the representation? If it
That
is
is
not national highways land,
Lordship.
the project director will not have any
No,
authority.
no, my lord. No,
So
my lord.
let her come back with instructions. Affidavit of service. None appears for the private respondent despite service. Paragraph, the petitioner complains that the private respondent has raised raised unauthorized construction by encroaching upon a portion of the national highway.
National highway.
Paragraph. Learned Counsel for the National Highways Authority of India submits that it needs to be ascertained as to whether the road in question is under control of the National Highway. National Highways Authority of India. Paragraph, Learned Counsel seeks to take instructions in this regard. Learned Counsel. Repeat হলো বলে আগের লাইনটা বলুন হ্যাঁ এর আগের লাইনটা কি বলেছিল it needs to be ascertained ঠিক আছে paragraph, let the matter appear under the same heading on 3rd July.
My lord. How do you?
ये दीजिए स्लिपটা
I beg to appear on the petitioner, my lord. My petitioner before you is a businessman relating to the sand, my lord. Petitioner, my lord, has applied for short-term mining lease, my lord, that is at page 18, my lord, by depositing the requisite fees, my lord. I am paying for only
Who is
consideration.
appearing for the trading corporation? Mr. Shah generally appears.
He is appearing for the state.
Under the state.
He is appearing for the state.
ADM, my lord. I applied before ADM, my lord.
The MDTCL should be made up. Where is your affidavit of service?
It's a good.
Have you served the third respondent?
No, my lord, I have applied for ADM before the ADM, my lord.
You have
This one-
included him as a party. Where is the service on third respondent?
Don't know, service searcher?
Mineral Development Corporation is a separate entity altogether.
Yes, yes, my lord.
My lord, I am appearing for the petitioner. Yesterday the.
You are appearing for the
Petitioner.
petitioner.
কালকে notice নিয়েছি।
ও কাল notice নিয়েছে?
Yesterday the brief was handed over. Then
Petitioner.
But he said, well, no,
He is appearing for the petition.
he said he took the no objection from the client. I put instruction. On 11, 12, দুটোতেই তুমি?
11.
No
Only
objection is
11.
given by the learned counsel as far as I know, not the client.
Abdul Samad Singh to clear up that.
Mr. Shah,
This one.
it has not been served.
It
at
is,
all.
you do it.
You can first kalki kotoka. Consideration.
No matter.
Yes,
দিয়েছে হবে না
yes, please place your case.
Case for consideration of a
You
representation.
have not served the third respondent, the MDTCL.
The affidavit of service is not on in the brief, my lord.
Affidavit of service is here, it has been filed, but then
We will forward it, we will forward
I
the.
think you're appearing,
Take my lord. My lord in these.
Only they will consider the representation and dispose.
Kotha is there, my lord. And next. Matter, my lord, I am-
he's primarily asking for consideration of a representation.
Only.
But then the mineral development should be, is a party. So will you serve a copy of the repetition?
I can give it here and now, my lord, let him take it. And my lord will kind of trigger direction to consider a representation within a reasonable time and dispose it. That's the only simplest way.
Where is your representation?
That's a P1
At
I think
page?
11.
at page. That's the annexure, your lordship will see, kindly consider. At page 18 onwards.
You're applying for short-term mining license.
It's their discretion, let them consider my application and pass on.
Yes? Affidavit of service.
18. 18.
No, next item.
None.
The petitioner prays for consideration of his application for grant of short-term mining license made before the concerned authority on
11th
11th January 2023. Paragraph, upon consideration of the submission made on behalf of the parties, comma, the writ petition is disposed of, directing the, who should be the authority?
Well, it's a DM.
ADM, the sixth respondent to consider and dispose of the application submitted by the petitioner dated such and such within 1 month.
Well, we get shorter time because once a
Shorter
monsoon
than 1
sets.
month is not possible.
Yes, ma'am, 1 month.
Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law.
Great.
Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Great.
Disposed of. It's fine.
Grateful. Yeah, I agree.
For the petition is the same as item 11, your lordships.
The mineral development, you,
My lord,
have
you
you
can serve
served?
me.
Have you served
I
the
don't
mineral
know.
development?
No. Have you
No,
served?
give him a copy.
Please.
Please give him a copy. Where is your representation?
Page 18, your lordships.
The third respondent. Same audit. Third respondent. Representation date is 9th January 2023. Within 1 month.
My lord, may I kindly pray that my lord indicates that the copy has been served in the court today, my lord.
Have you served the copy?
He has not served, my lord. My lord,
Immediately. Here
also
and
in
now.
the, my lord, previous matter, my lord, kindly indicate that the copy has been served at the time of hearing of the matter, my lord.
Very well. দুটোতেই
Upon-
করুন, একটা লাইন অ্যাড করুন। Copy of the writ petition is served upon learned counsel for the, your respondent number? 3.
3, my lord.
ইয়ে করতে বললাম কাকে?
Yes, my lord. Respondent number 3.
Consider করবে কত নম্বর?
আপনার এখানে কত আছে? Mineral development?
কত নম্বর respondent? Oh, okay. A copy of দুটোতেই add করুন, copy of the writ petition is served upon learned counsel for the third respondent in court this day. দুটোতেই sir. Affidavit of service এর পরে এটা। Yes, next.
They to appear on behalf of the petitioner. My lord, in terms of my lord's last order,
Respondents,
respondents were to file a report, my lord, in
I'm
the form of
praying
an
for
affidavit.
not today, my lord.
My lord, the report has not yet been, my lord, served upon us, my lord.
it should be ready to be served, isn't it?
Report টা ready হয়েছে?
Yes.
The report টা file করে দাও না, আমাকে একটা copy দিয়ে দাও। হ্যাঁ। He has the report, my lord.
Today I am filing on the review.
And maybe have a copy so that we can see the report and come back with an exception if any, my lord.
Have you served a copy?
My lord, just now
Yes.
I have been served.
Report in the form of an affidavit. Mr. Dey, you're appearing in this matter. John, Mr. Report in the form of an affidavit submitted on behalf of the third and fourth respondents is taken on record. Paragraph, copy of the report is served upon learned counsel for the petitioner in court this day. Paragraph, the petitioner seeks to use an exception to the said report if required. Paragraph, let the matter appear under the same heading on 5th July.
Grateful to your lordship. 5th July এত short date দিচ্ছে তা তো হচ্ছে না। Human beings are never satisfied. My lord is giving such a short returnable date. My learned junior is still insisting for a shorter date.
It's short enough.
Grateful to your lordship.
May please, madam.
And for state lodge.
This is the second round of litigation. When the grievance is encroachment of public land by private respondents in front of my plot of land.
Have you served the private respondent?
Yes.
You are appearing, very.
My lord, on the earlier occasion, my lords were pleased to direct the authorities to the usual order, my lord, to inspect and file a report and take action in accordance with law. My lord would kindly come to page 85 of my lord's brief. My lord.
Who is appearing for the state?
I'm appearing for state lodge.
85 to the-
Page 85.
85 of my lord's brief.
Yes.
My lord will kindly come to the penultimate paragraph, my lord. Second last paragraph. Shri Kalipodo Shamanto and 6 other private respondents agree with the above noted statement as they are running their business over the government land, but they are maintained their livelihood by their business, so they are requested not to remove their shop rooms. Well, this is the usual mercy prayer by the private respondent who is encroaching the government land. Now, my lord, in order to, this is an order passed in the year 2020. After that, we serve upon the authorities several communications indicating and requesting them to execute their recordings. They sit tight on that. And my lord, in 2023, in order to hoodwink, if I'm allowed to use this term, this honorable court, my lord, the RI and the local BLLRO, my lord, this is 1817 big plot, big dag number. They demarcate it, divide it, and make a bata dag number. And in the bata dag number falls the dispute, my property, as well as the encroachment. And my lord will now come to the impugned order, my lord.
Is this under the 62 Act or the 64 Act?
64 Act, Public Highways Act.
State highways.
West Bengal
Highways Act.
Highways Act. And my lord kindly comes to the impugned order, which is at my lord
99.
Page 99 of my lord's brief. My lord, I need to place the entire impugned order. My lord, will grant me that liberty, my lord. The matter has been taken up for hearing today, that is such and such, in the chamber of the undersigned for passing a second reasoned order in compliance with the order of Honorable Justice Shobhushachi Bhattacharya of the Honorable High Court, Calcutta, dated such and such in the matter of such and such. Arup, these all are present. BLLRO, everybody is present. Shri Arup Kumar Bagh, petitioner of the instant case, stated that the plot number 1817 is divided in Bata plot by the concerned BL and LRO, and his possession of the said Bata plot being dag number 1817/2442. He also demanded that the private respondents of the instant case have made illegal encroachments on the government land in front of the petitioner said Bata plot, for which the egress and ingress of the petitioner is obstructed. Shri such and such and 6 others respondents objected that Shri Arup Kumar Bagh, petitioner, is not owner of plot number such and such. Maybe. Let me finish. Shri Arup Kumar Bagh, petitioner, also failed to produce any evidence, documents in support of his statement. My lord, kindly turns over the page, my lord. As per representation dated such and such, annexure P4 in the writ petition expeditiously, wherein the petitioner himself demanded that the owner of plot number 1817, jail number 4, Mauja Kakpur, and the private respondent of the instant case have made illegal encroachment on government land in front of petitioner's plot number 1817, and also requested to remove the encroachment as per West Bengal Highways Act 1964. Next, in the meantime, the BLN LRO Potashpur demarcated the plot number 1817, jail number 4, Mauja such and submitted the demarcation report, wide his memo dated such and such, wherein he stated that the private respondent of the instant case are not encroaching the government land to PW Roads Directorate in front of plot number 1817, jail number 4, Mauja. Kindly marks this. My lord, by this demarcation, may I pause for a moment? What they have done is, my grievance initially was that I have a plot in 1817 and the encroachment is on adjoining 1817. Now they demarcate it. They create a separate Bata dag number, and they are silent whether there is encroachment on Bata dag number. But they say that your grievance was encroachment on 1817. As of today, there is no encroachment in 1817 because the encroached part has been demarcated into Bata dag. Now, my lord, next, my lord, the demarcation report of the concerned BLN LRO has already been served to the petitioner and the private respondents at the time of hearing by the undersigned. Having heard the petitioner respondent as per the report of the concerned BLN LRO, it is noticed that the private respondents have not encroached any government land in front of the plot number 1817. So the West Bengal Highways Act 64 is not applicable for the instant case. And my lord, I will also like to invite my lord to the report of the RI, which is at page number 88 of my lord's brief. My lord, it's in vernacular, my lord. I would request my learned friend to please.
Second paragraph, my lord. সরজমিনে পরিমাপের শুরুতে দেখা যায় যে এলআর মৌজা দাগ অনুসারে পিডব্লিউডি রোডস এর পাকার পূর্ব দিকে 1817/2442 দাগে আবেদনকারীর একটি ঘর রহিয়াছে। উক্ত পাকা রাস্তার পশ্চিম দিকে 1817 রহিয়াছে। উক্ত 1817 দাগের সম্মুখে পিডব্লিউডি রোডের বিবাদীগণ কোনোভাবেই দখল করেন নাই। 1817।
Even the impugned order is absolutely silent on the fact that there is admittedly an encroachment, which I had shown to my lord, now in Bata dag number.
But this says that Bata, in the Batadag also there is no encroachment. Page 88 says so.
No, এটা বলুন বাংলাটা বলুন।
উক্ত পাকা রাস্তা পশ্চিম দিকে এত রয়ে যাচ্ছে উক্ত 1817 দেখে সম্মুখে পিডব্লিউডি রোড যায়।
Paka rasta purbo dike to the east of the Paka rasta is the petitioner's land
Yes.
house. And to the west,
1817.
1817. In 1817, there is no encroachment.
But in 1817 by 124, there was encroachment.
but the demarcation report needs to come.
Page 100.
They have themselves admitted, page 85.
Page 100, man. Page 100.
Page 100.
No.
Page 100 is the order. Yes, but there should be some reasoning to this. I'll get back with the report. The order passed by the executive engineer, Tomluk, executive of service, Tomluk Highway Division, comma, Public Works within bracket roads, bracket close directorate, on 28th February 28th February 2023 is assailed in the writ petition. The petitioner, paragraph, the petitioner has alleged unauthorized construction made by the private respondents by encroaching upon a portion of government land. Stop. Pursuant to a representation submitted by the petitioner before the concerned authority, comma, the entire plot being dag number 1817 has been demarcated by the state respondents and a bata dag being 1817/2442 culled out from the same, CULLED, culled out from the same. Stop. The order impugned records that no portion of the bata dag has been encroached upon by the private respondents. Stop.
May I indicate, my lord? The order records that no portion of 1817 has been encroached.
No portion of plot number 1817 has been encroached upon.
That is any number, man.
Bata dag.
Ignoring the fact that bata dag has been culled out.
1817 any number, man.
No portion of plot number 1817 has been encroached upon. The order is by the private respondent. Stop. The order is silent with regard to encroachment, comma, if any, comma, in respect of the bata dag culled out from the original plot. Paragraph, learned counsel for the state respondents seeks to submit a report in the form of an affidavit annexing relevant documents. Paragraph, let the matter appear under the same heading on 4th July.
I'm deeply obliged.
4th July.
My lord, I am for the petitioner. Yesterday, the matter was taken up for hearing, but service was completed, but affidavit of service was not.
You're filing your
Your
affidavit
lordship
today?
acts on that matter. Lord, what happened, my lord?
Who is appearing for the school and the
Only for my, consider the,
Mr. Guchat, you are appearing for the state?
consider the representation.
No, Mr.
Lord,
Guchat is appearing, yes.
My lord, page,
What is the matter about?
matter, my lord, the petitioner's lot of land adjacent to the, my lord, Paka Road. And my lord, the frontage of the petitioners, my lord, is obstructed by a constructing Paka structure, the headmaster. And therefore, my lord, he made an application before the subdivisional officer, Tonglu, to consider the case of the petitioner. Consider the case of the representation of the petitioner. My lord, he did not consider, and therefore, my lord, he has come before your lordships, page 39.
Sir. Sir.
This is under the 1962 Act.
Yes, ma'am.
Representation at page?
Page, my lord, 39. Annex 35.
Yes, Mr. Guchat.
My lord, this is under 1962 Act. My lord, their allegation is that, my lord, the headmaster has raised a boundary wall covering some, my lord, egress and egress portion of the petitioner on the land of the, my lord, government. But, my lord, this is 1962 Act. Collector is required to be made as party. My lord, he hasn't made the collector a district magistrate.
Subdivisional magistrate, my lord, is the.
Because in the 1962 Act, my lord, collector is the authority. HDO and collector.
SDO is the
HDO is the authority. Collector, then HDO. HDO is made as party. Then you will also direct the HDO to consider the representation and decide.
Affidavit of service. None appears for the private respondents despite service. Paragraph. The petitioner complains that the private respondents have raised unauthorized construction of Pakka structure on government land adjoining his property, thereby blocking his egress and ingress completely. Stop. The petitioner submitted a representation in this regard before the concerned authority on 18th August 2022, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. The apology none appears for the private respondent despite service bodies. Paragraph. It is submitted on behalf of the state respondents that the third respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months, because proceeding has to be initiated. Within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of for chapter.
Good.
I am for the petitioner, man. Affidavit of service. All are served, man.
Private respondent is served.
Served, man.
State, no one is appearing. Yes.
In front,
So they may I request you.
in front of the petitioner's land, my lord, there is a PWD land. That PWD land was encroached by the private respondent. I made the representation, my lords, before the authority. Let it be considered, my lords, at page 25, my lord.
Respondent number কত? দাঁড়াতে।
Mr. Then let it be considered.
Yes, madam. Respondent number.
Affidavit of service, none appears for the private
Yes, madam.
respondent despite service. Paragraph, it is contended on behalf of the petitioner. By it according the petitioners claim to be. The petitioners claim to be the recorded owners of the plot in question
ঠিক আছে।
and submit that the private respondent has raised unauthorized construction by encroaching upon a portion of PWD land adjoining their property, comma, thereby obstructing their egress and ingress. The petitioners submitted a representation in this regard before the concerned authority on 23rd March 2023, which is yet to be considered. Stop the petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the
By the respondent number 4, madam.
state respondents that the fourth respondent be directed to consider the representation in accordance with law. In accordance with law, stop. Paragraph, in view of the above, comma, that it petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted on behalf of the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, comma, in accordance with law. Disposed of.
Grateful.
State regulators code. Please serve a copy of the petition to Mr. Dean. Served.
তারা এদিকে ডান দিকে। May I please, your lords. This is also usual case of
The none case to the respondents.
this is also a usual case of unauthorized and unlawful construction in front of the residential.
What about the
house of
private respondents?
Yes, yes. They have received, my lord. We have made a representation.
Give me a minute, please.
ছবিটা, huh? Yes, yes. খুবই দরকার হবে? দরকার নেই? তুমি আসলে চিন্তা নেই। Kindly see, my lord, this is our দেখাও দরকার নেই। Your lordship, kindly direct the district magistrate to. Assistant engineer. তাও আছে। Assistant engineer respondent number কত?
Where is your representation?
Yes, page 24. My lord, respondent number 5, assistant engineer. This is irrigation land. The private respondents, my lord, are very.
Irrigation land. তাহলে এখানে কি পাবলিক প্রেমিসেস তো আনসার স্ট্রাইক ওয়ান্স সেশন PWD land বলেছেন।
Desperate people. My lord, in front of my house, this is the building they are making.
Let them consider.
Yes.
Well, the SDO concerned is the authority, or not the public premises. If it is the land of the irrigation department, it is not the highway.
He says path, ekmatra boram path.
Yes.
It's a PWD road.
Now he is saying when it is the land of the irrigation department.
Please see the representation, it says road.
Irrigated land, my lord, by this.
না জমি জায়গা PWD না irrigation.
Irrigation.
তাহলে এখানে হবে না। Public premises in unauthorized occupant sector. Then SDO is the authority, man.
SDO is the authority. Have you impeded the SDO?
Yes. Subdivision officer, respondent number 6.
SDO কে একটা অ্যাপ্লিকেশন রিপ্রেজেন্টেশন তাহলে দিতে হবে, হ্যাঁ সেটা দিতে হবে।
So let the sixth respondent decide.
Yes. And we shall file if necessary fresh representation.
Not necessary.
Yes.
Let this be decided by the sixth respondent.
Yes.
Affidavit of service, none appears for the private
Let him
respondents.
make an application before the SDO.
SDO?
SDO concern. Comprehensive repair, that should be complete.
Yes.
None appears for the private respondents despite service. Affidavit of service according. The petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon the land of the irrigation department, the land of the irrigation department adjoining his property, comma, thereby obstructing his
But
egress
actually
and
in front
ingress.
of my house.
Adjoining your property,
Yes.
that's what I said. The petitioner seeks to submit a comprehensive representation in this regard before the concerned authority and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the sixth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the sixth respondent within 7 days.
Yes.
Within 7 days from date. Stop, the sixth respondent is directed to consider and dispose of the representation within 3 months from the date of receipt thereof.
My lord, because they are making construction is still on.
Proceeding has to be initiated.
Yes. Within 1 month or
Within-
1.5 months.
Proceeding cannot be concluded within 1 month. Upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law.
I'm greatly,
Disposed of.
extremely grateful, my lord. So,
Well, in this matter, I beg to appear on the petition. Mr. Goswami is appearing for the state, my lord. He said he is not getting brief, my lord, yet. So kindly make this matter only not to the my lord. Is he? Ganguly,
Where is he?
18. He said me just. Ganguly, Mr. Ganguly. Mr. Ganguly.
18 state কে হয়েছে আচ্ছা অসুন্দর
Ashim Ganguly appears for the state.
Yes,
Mr. Ashim Ganguly appears for the state.
he said me, he has
He has
told
not
me.
corrected the brief.
Yes.
তুই কি আছিস ওখানে? তাহলে করে দে।
On prayer of the state respondents, the matter is adjourned. Let the matter appear under the same heading on 5th July.
He said me, that is why
মিনারেল ডেভেলপমেন্ট
I said me. ঠিক আছে, জানা
আপনি টাইম চাইলেন আমি কোথায় করবো
ঠিক আছে।
You are representing the state in this matter?
Yes.
Well, I beg to appear in behalf of the petitioner. matter. Well, this matter relates to my lord, long-term mining lease, my lord. Petitioner was initially successful.
may I just raise the point of mentality? So item 19 to 23, all are applicable
22.
order. 22.
Yes.
So these all are applicable order in terms of rule 51.
No, judgment order to. My lord,
Initially, there was a representation, they filed a writ petition, this honorable court directed the ADM to consider. After consideration, the ADM passed an order, that order is under challenge. In terms of rule 51, that order is applicable.
no, my humble submission before your lordship, this issue has primarily been decided by Justice Sengupta also, my lord. Now, my lord, the rule 51, if your lordship kindly take table to rule 51 once.
Give
my
me a
lord.
minute.
May I just hand over?
51.
Minor mineral rules আছে এখানে।
এটা দিদি এখানে
কিভাবে রেখেছে কেন বইগুলো পাওয়া যায় না। Minor minerals concession rules. Thank you.
Yes. Order work. Order আরেকটা কপি লাগতো।
There is one catch in this section.
Yes.
Duly authorized by the district authority in exercise of powers conferred
Yes.
upon him by these rules.
Yes, my lord.
So was this petition application disposed of in terms of these rules?
Then only applicable, otherwise not.
So
Well, this is the same view observed by Justice
Please
Sengupta.
come.
granted,
51.
lease granted through this rule.
This order is made in exercise of powers conferred upon him by these rules.
Because the lease was granted by this concession rule itself.
Well,
Because that
may I
is
just show your lordship two things, my lord? Well, kindly take table to look at page 37 once. At first, my lord. Page 37, second paragraph. My lord. A new mining rule, that is West Bengal sand mining, huh? 37, my lord, got it, my lord?
No, that is a
You see,
different
that is
issue.
the policy. The ATM has
My
recorded
lord,
because of
my
the-
contention is that if this order was passed within the purview of the rule, then it is appealable, otherwise not. My lord, kindly see that same observation was passed by Justice Sengupta. It is in prima facie view, my lord.
কি করেছে?
Same point was raised therein also by my learned friend, my lord.
Lease.
কালকে কেস নাম্বারটা মনে আছে? একটা লাগতো অর্ডারটা। একটা অর্ডার।
লিজটা অ্যানেক্স করেছে, লিজ অ্যানেক্স করে লিজে ছিল এই অনুযায়ী।
কত?
চারশো সতেরোশো কালকে ডিসকাস করি।
Here the extension was rejected.
Yes, my lord. The extension application was rejected. Same matter, my lord. The same point was raised by my learned senior friend therein also.
Yes, how do you justify your point?
Also, the lease which was granted, that was in terms of Rule 38, grant of prospective license come mining lease for expression of mineral, minor minerals. So the sand is admittedly minor mineral, and the lease was granted in terms of this West Bengal minor mineral concession rules. So if the petitioner wants an extension of the mining lease granted through this rule, so any order passed on that application, it also cover under this rule. The lease has not been annexed with this writ petition.
Lease admitted. Lease টা লিস্টটা বার করো পুরনো লিস্ট।
Where is the provision for renewal of lease in this rule, in this rule?
The renewal or extension part is made itself in the lease deed.
Lease deed.
Lease deed has not been
That is
annexed
not
to
in the
writ petition.
provisions. That is, my lord, that is why I show your lordship page 37.
There is a chapter 5 clause.
Chapter 9 clause 5.
Chapter 9
Clause
clause
5.
5.
My lord, that is my humble.
Judgment that you, the order that you refer to deals with section rule 21.
As well as 51. If your lordship will come, my humble, the point.
It's 51 in connection with 21.
21.
But this is not applicable in your case.
No, my lord, if your lordship kindly give me a once order, my lord. It is also for the extension application. He submitted the rule 21. That is that my lord says that is also not applicable in this case. My learned friend submitted the point 21.
Rule 21 is not applicable at all in this
This
case.
is his submission.
That is when you have, no. That is when you have not commenced the mining operation.
Yes, my lord, here, my lord, two things are there in this order. One, my lord, he submitted rule 51 appealable, that has done well. No, there is sufficient merit. Second point, he raised that 21 is in the rule. My lord was observed that 21 not is applicable in this case. 21 was applicable when the lease was not commenced within a period of 1 year. That is made clear here in my lord. This is the same matter, my.
Here also, when 21 is not applicable,
Yes.
section 51 applies.
No, my humble submission, my lord. The 51 applies when
Lease was granted in terms of these rules.
my lease, my kindly, my humble submission, my lord. The ADM himself submitted that there is no provision for extension in the rule. Where the 51 says, my lord, a person aggrieved by an order made by the district authority or officer duly authorized by the district authority in exercise of the power conferred upon him by this rule.
What is that exercise of power? It is grant of lease.
Exercise of power only, my lord. But here, my lord, I prayed for extension on the basis of the
I'm
clause.
sorry, sir. I cannot help you.
So, my lord, kindly, my lord, one thing, my lord. Kindly, my lord.
I'll grant you liberty to approach the appropriate forum.
My lord, kindly, my lord, my lord,
And
kindly.
your limitation period will be.
My lord, kindly, my lord, kindly see once the order, my lord, kindly, kindly, my lord, allow me to it order to din.
I have seen the order.
Kindly see, my lord, they here it order to din na. It to din order. My kindly see once, my lord.
Order says section rule 21 is not applicable.
Rule 51 is not applicable here in this extension case. My lord, kindly see, my lord, once order.
The
My lord, kindly see, my
I've
lord.
seen the order, sir. How
Once,
can
my
I-
lord, for my satisfaction.
Reiteration will not help. I've seen the
For
order.
my satisfaction, kindly see, my lord, may I read, my lord? Well, kindly see, my lord. What is the matter about? Learned senior represent the petitioner further submits as follows. The petitioner was granted sand mining Burdwan for a period of five years. However, due to the concept of COVID pandemic and due to the obstruction created by local, here also, my lord, COVID is one of the point, my lord. First paragraph, my lord. Now, my lord, kindly see the petitioner paid for extension of mining lease by an order dated petitioner was granted to Liberty as comprehensive representation. Herein also, your lordship directed me to submit a representation. I went there, they have rejected, my lord. Now, my lord, Learned Council for the state relies on the report submit. There is a provision for extension of the lease contained in 21. This is the submission by there.
That was submitted
Well,
on behalf
let me
of
allow,
the
my
state.
lord. Let me allow.
You cannot put something.
My lord, kindly see that this order is appealable under, this is the submission of under 51 of the relevant rules. And Learned Council state realized that the extension of the dispute contained in Rule 21 of the 2016. This is his submission. Now, my lord, lastly, kindly see, my lord. Prima facie, it appears that there are good reasons for petitioner not to able to do the sand mining its fullest and it is responsible for the respondent to the provide cogent. After all, the petitioner paid the duality. Thereafter, it does not cover the dispute at the hand. As such, there is a merit in the contention of a petitioner. His submission is
Separate circumstance altogether, sir.
my lord, one, my
The
lord,
submission of the development corporation was that rule 20, according to rule 21, there is no
my
provision.
lord, my lord, my
But
lord,
rule 21 is, here you had started mining lease. After that, you could not continue.
my lord, my contention herein is that due to the COVID, I could not continue the lease. I have
You had commenced operation, you
yes,
could not
I
continue.
am not. I'm
Rule 21 is not applicable.
no, my lord.
The
If Rule
lease
20,
was granted in terms of the rules of this.
my lord, I paid for extension on the
I
basis
will
of a
not
on the.
spend further time on these.
Well, kindly see, my lord, they are on observation. There is no such rule for extension. There is their own admission. Page 37.
It is admitted that there is no such rule for
If
extension.
there is no such rule, how
Extension
51
is-
applicable, my lord?
Extension is provided by the deed which is
Yes.
under the rules.
Well, but
The deed was granted in terms of the rules.
my lord, kindly
So
see
section
once, my lord,
51
there is no.
applicable.
Kindly, my lord, consider, my lord. If he passed the order within purview of the rule, I could have understood, my lord. This is not. It
The
is
deed is-
maintainable, my lord.
The
If
deed is not divorce the rules.
deed is not divorce the rule, but
The
a clause.
deed contains a clause for renewal.
Well, then the sections provide so that he passed order within the.
What is your difficulty in appeal, sir?
Well, the difficulty is the appeal is. that, my lord,
I'll
it took
condone the limitation.
a kindly short time frame because they make a third party right, my lord. That is
I'll
the difficult.
condone the limitation.
So that fine, right
Within
before
7
that-
days?
yes, my lord,
You
condone
appeal
that-
within 7 days?
yes, my lord.
You will prefer the appeal within 7 days?
Yes, I will prefer the appeal. My lord, kindly, my lord.
You
only-
can direct the divisional commissioner to conclude the appeal within a particular time. To that also I have no objection.
Within that cannot be done.
My lord, kindly, my lord, only protect my rights. Otherwise, my cause. If a third party right,
It's
yes.
not maintainable, right cannot be protected, sir, you're aware.
Well, kindly, my lord. Otherwise, my right will, well, I will be highly prejudiced, my lord. If the third party right will be created therein.
Order,
ওটা আমাদের বলা দরকার নেই।
শুনছি, 19,
The order passed by the additional district magistrate and district land and land reforms officer, comma, Purbo Bardhaman on 21st March 2023, the date,
Yes, madam.
21st March 2023 order is
Order.
assailed in the writ petition.
Lease.
The order is
9th
amenable.
January 2018.
The order,
No, order is
21st March 2023, the
21st
impugned
March.
order.
Yes, yes.
The order is
March
amenable to appeal under Rule 51 of the West Bengal Minor Minerals Concession Rules 2016. Paragraph in view of the above, the writ petition is dismissed as not maintainable. However, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph in the event the petitioner prefers a statutory appeal within 7 days from date, 7 days or you need more time?
7 days.
Within 7 days from date, comma, the appellate authority shall deal with the appeal on merits and not dismiss the same on the maintainability issue. The appellate authority is further requested to dispose of the appeal as expeditiously as the business as expeditiously as its business would permit. As its business would permit. Paragraph, there shall however be no order as to costs. Urgent certified website.
Up to 22, my lord,
Sorry.
similar matter. Up to 22 similar matter, my lord.
Up to 22.
Huh.
20, 21, 22. Same order.
Only my lord, date of expiry.
Date of
order.
Impugned order.
One by one.
Yes.
Daran.
Next matter, date is 30th January 2023.
23 would be.
20.
Order of the ADM is January 30, 2023.
At page. Uh, 30th January 2023 order.
In 21, the date is 3rd January. Oh, no, sorry. 30th January.
21, 30.
30th January.
The part last to the
22 also 30th January.
30th January. 30th January. Make question. January 2023. 2023, 30 January 2023.
Lord, I did not reach when my lord called the matter item number 3 CPN, that is contempt.
Item number?
Item number 3. Lord, I do not know.
Mr. Sengupta, we are in 23.
Yeah, I know.
So let us focus on 23 and not 3.
No, 23, my lord,
23.
Lord, I beg to appear on behalf of the petitioner.
Yes.
Statement.
Yes.
Lord, a notice of closure of my brick field.
Have you served the private respondent?
My lord, I have sent it, my lord, not received.
So you have to serve and come back, sir.
My lord, only one thing, my lord, if I may make, my lord, this prayer.
Your track report is also not annexed.
No record. No, my lord, no receipt here, not.
Please serve and come back.
I have served yesterday, it was not annexed.
So please complete service and come back.
Lord, a closure notice is under challenge without affidavits, my lord, it cannot be so.
You have to first serve, sir. Then only I can pass an order.
As a lordship pleases.
Service upon the private respondent is not complete. Let the matter stand over till 6 July.
Lord, 6 July, my lord, there is, my lord, some urgency, my lord.
the closure notice, my lord, has
Anyway,
been
27 June. this month.
27 June. I'm extremely grateful.
Next. Yes, anyone appearing?
My lord, I am for the petitioner, I am praying for not today.
On prayer of the petitioner, have you served the respondents? Do you have the affidavit of service with you?
My lord, I am instructed.
Please go through the brief, madam, before you come before a court. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 6th July.
My lord, I am for the petitioner. My lord, I am for the statement. My lord, petitioner is a member of uprooted family. The land was acquired by the government for implementation of the
Take the microphone, please.
for implementation of Indo-Bangladesh border road, my lord. I am the member of the uprooted family. My lord, I have applied for land loser certificate, issuing land loser certificate in favor of me for enlisting my name as a land exempted category under the National Employment Exchange card, my lord. So in Peskai form, I have applied on, my lord, 4th September 2018. That yet not been considered, my lord.
Where is your application?
My lord, at page 25, my lord, in Peskai form, I have applied. Sir.
Yes, Mr. Kuchai.
My lord, he has applied, my lord, that is in the year 2018.
And you have not considered that is also true.
It has not been considered. And the question is that, my lord, he is saying, my lord, that he is landlord and his dwelling house as well as, my lord, cultivated land has been acquired by the government. That has been the year, my lord, 1996-97. And 1998, my lord, entire, my lord, commercial amount was paid to him. But he has not annexed any document regarding that his dwelling house, because there is a scheme. The person whose dwelling house as well as other lands has been
When you
acquired by the.
call petitioner for hearing, he will produce.
Yes. That's why. Let the yes. Upon opportunity of let the form be, my lord, consider upon giving an opportunity of hearing to the person.
Well, this is a scheme for the government. Well,
All
I am taking. This is a scheme for the government. If any person, family is uprooted and for the development of the for the development purpose, my lord, that is, my lord, there is no problem on it. That is why the government introduced, my lord, they should be treated as an exempted category, not for any appointment, only recording the name in the National Employment Exchange as an exempted category for future appointment.
Yes.
In accordance with law, the process, due process. So that was made, but till date, my lord, there is no response at all.
Let the government consider your application and please produce relevant documents in support of your claim.
Yes. That's and after opportunity of hearing,
Absolutely.
according opportunity,
Absolutely.
within a specified period of time.
Affidavit of service. It is contended on behalf of the petitioner that the land of the petitioner was.
My lord, may I take leave, my lord, subject to your
Was utilized by the respondents for constructing Indo-Bangladesh
Indo-Bangladesh border road in the district of Murshidabad. And compensation was paid to the father of the petitioner on 14th October 1998. Stop. Since the petitioner has been uprooted from his place of residence due to such utilization, comma, he applied before the concerned authority for recording his name in the exempted category as a land loser. Applied before the competent authority on concerned authority on what's 27th August 2018.
Yes.
On 27th August 2018. Stop the said application is yet to be considered. Stop the petitioner prays for a direction upon the authority to consider the application at the earliest. Paragraph, it is submitted on behalf of the respondents that who should consider?
My lord, he has applied before the
The district magistrate.
BDO. Ito. Block president of C, sir.
The third respondent.
Third respondent.
The third respondent be directed to consider the application of the petitioner,
Correct.
subject to the petitioner producing all relevant documents in support of his claim. Paragraph, in view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the application submitted by the petitioner dated such and such, upon affording reasonable opportunity of hearing to the petitioner, and upon consideration of the documents
Yes.
to be submitted by the petitioner in support of his claim.
Yes.
ওখানে বলেছি কতদিনের মধ্যে ওখানে ডিসপোজ within 1 month. Sufficient. Within 1 month from the date of communication of this order, তারপরে upon affording. Paragraph, paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of with check.
Grateful.
I plead your lordship.
Item 26.
In this case, I challenge the entire acquisition proceeding initiated by the government.
Who is appearing for the respondents?
I'm appearing for 8 to 13. May I file my affidavit, your lordship, and directors file the affidavit in form of a report. It's been received by them, they have filed their reply also. That is the ability to reply given against the respondent number.
Who is appearing for the private respondents?
I'm appearing along with my friend for respondents
I'm-
8 to 13.
I'm appearing for the official respondents.
1 to 7. Right. Yes.
One can is my lord, can number 1, my lord, is regarding amendment. Another can was made, my lord. That is a production of some document as per report, my lord. I shall not press that can number 2.
You are not pressing can number 2.
Oh, yes, my lord. Because the record produced by themselves is sufficient to specify lordship regarding my. Your lordship was pleased to grant me leave to file amendment petition regarding description of the property, schedule of the property. I accordingly I find the application that is the can number 1.
Please take the microphone, sir. You're
That
not
is the
heard.
can number 1, my lord. That is can number 1, I find.
Well, can number 1 is for amendment of the writ petition. my lord. But the prayer is, my lord, kindly come to para 30.
Can number 1 is for early hearing.
That's right.
That's
That is exactly the point.
exactly
you
the point, my
raised.
lord.
Your lordship had granted him leave to amend the writ petition to show that he has a locus to file the writ petition.
Right.
Can we have a look at the prayer?
Can number 1 only asks for early hearing.
That's all. Yes, my lord, but it is a, my lord, some mechanical mistake. I do not dispute it, my lord. Mechanical I mistakes. mechanical dispute, my lord. It was mentioned, my lord, in the reading of the entire petition, your lordship and lordship have already granted.
But without the prayer?
Yeah.
Even
Yeah.
in the amendment application that he has filed, can 1, but I have my reservations on it, I shall deal with it.
I may be, my lord.
My preliminary points of demur, which I. Can 1 actually doesn't have a prayer at all? Nothing at all. It's as good as not being there. And where is your schedule of amendment? Nothing. It's not there.
Scheduler amendment is not given, my lord, but I given the description.
I'm sorry, sir, nothing is actually given in your application.
And one also has to be thrown out.
No, my lord. I would request you to.
Besides amendment, my lord, your lordship, they submitted report. Your lordship is satisfied from the report, it is a fair proceeding. I have no case. If your lordship makes, I didn't
So will
face
you
anything.
will you
I
not-
challenge. My lord, original petition, I challenge.
Will you not press both the cans, both the applications?
No, my lord, I shall, I shall kindly leave, to correct the same. Kindly give.
How can you correct this
Tomorrow.
application? It is entirely wrong.
Regarding schedule, my lord, I shall.
It is entirely wrong, sir. You cannot correct. You have to correct the entire application.
Fresh, I will give the other short
My
time,
lord.
my lord. Because that is my.
The last occasion, my lord.
Junior committee
Lordship was
mistake.
categorically asking the petitioner, where is your right over the properties? And on that, they sought amendment of the petition. My lord. Because as of now, in the entire writ petition, they could not produce any document showing their right over the properties. Because we have directly purchased from the Patadas, my lord. And after purchasing from the Patadas, we have already that land record has been corrected. And it is for a particular purpose, my lord. There is a famous folk singer from Assam, Pratima Pandey. She was equally popular like Bhupen Hazarika. In her memory, entire family, everybody is supporting this cause, my lord, except this petitioner, my lord. So now let the petitioner say what is her right over the property, because we have purchased from the Patadas, as I told, my lord. The money has already fully and finally been paid to the, and property is located in Assam, my lord. Property is located in Assam, my lord. Even otherwise also territorially, my lord, this honorable court.
Petition, this court has stated.
That apart, my lord, they have suppressed 3 documents, my lord. One is the commissioner's report, one is the will probate, and then one is the probate of the will. So on that basis, they have Patadas have got the right over the property, and we have directly purchased from the Patadas, my lord. Where do they come in picture, my lord?
That is a fact, my lord. They had knowledge. Government has knowledge. There is a case is pending in the Calcutta High Court. I raised the objection before my.
That case, my lord, they could have filed the appropriate application, that pending suit, my lord. Instead of coming in writ petition, my lord.
I raised objection regarding on the 2021.
Is the writ petition maintainable? There is
That is the issue, my lord.
That is the issue,
my lord.
The property is my lord, part of the partition suit.
Well, in that case, they should have filed their application.
Let me say,
Please let him.
this property, my grievance arose why? Because when I came to know that they are trying to sell the property to some private party, then came to know that they are trying also to sell to the government. Then I made representations. Yes, you see that there is a pendency of the suit in the Calcutta High Court. In that case, you are not bound because he is endeavored to transfer the land under section 52 of the doctrinal jurisprudence to come into operation. They did not take any heed, my lord. What they did, my lord, 12/1/2022, they started proceeding under new Act of Central Act. They constituted a committee. Committee sought report from the settlement officers. Thereafter, my lord, mood change. What they did, they published one order conflicting the order of the central government. That has been published. And under that publication, that order, they constituted a committee. How that committee will be constituted, my lord, ignoring the earlier committee? That is under Central Act. They started to function. under that act. It is that document, your lordship kindly see.
But these facts should have been brought to the notice of the court where the suit is
Yes, my
pending.
lord, they have submitted the report, madam. I need know because they produced
How
the
can
report.
the writ court intervene when the suit
Yes,
is
my,
pending?
That is the issue, my lord. That is the basic point.
Eh? Do show I kindly see them, my lord.
How can the writ court intervene, sir, when the suit is
Because
pending?
they, your lordship was
Disputed
there,
question,
how
right?
the district magistrate, respondent number 4 acted. They told before your lordship, they will take possession. Then your lordship was pleased to argue the file report. What is the, your lordship currently, he is the, my lord, the statutory authority, district magistrate, respondent number 4. So, in order to satisfy your lordship, how he function in the matter of proceeding, that is the purpose of the report. So, if the report is submitted and report shows that he acted maliciously, he misused his power, he abused the process of law, he produced the case much secretly, without giving any notice to any parties in the secret home, my lord. That is the record, my lord.
Where
Your
is
lordship,
his-
how the
not
process, my lord,
stated all
how
this in
this
your
proceeding
petition
can,
at all.
how the judicial proceeding can be taken secretly, my lord?
Have you made such contention in your writ petition?
Yes,
No,
sir.
no.
Yes,
No, my
yes,
lord.
your lordship, see.
Total suppression, my lord, in the
petition,
writ petition.
I amended the writ petition,
Please, yes,
my lord. I amended, that is a, my lord, amendment.
not amended, sir.
He
Please
amended,
try to
that is also raised, my lord. I raised the writ petition. Your lordship kindly see the writ petition. I challenge it. Immediate reply, we have stated.
Your affidavit in reply cannot be beyond your writ petition.
No, my lord, we have, your lordship will see. Because we stated, in the ground also, my lord, we stated page 17.
In the writ petition?
Yes,
Yes.
your
please show
lordship
me.
will see ground at page, writ petition page, my lord, 17, my writ petition.
Page 17.
Page 17, ground number 6. So you raised my, but you elaborated, my lord, everything has been taken in the writ petition. In ground number,
Yes,
attempt to
but
purchase.
where are you in this picture?
Yes, yes.
That is the issue, my
That is
lord.
the main writ petition, my.
Where they come in picture, my
That is
lord.
my, that alleged attempt to purchase
How-
the property.
Yes,
Please.
but how are you affected?
Yes.
How are you affected?
I am the part and parcel of the property,
It
my
is
lord.
not stated in the.
That is
writ
why,
petition.
my lord.
Please, sir,
Please.
please.
My
Where is
lord,
that in
what
the
is
writ
the,
petition?
I am, I
In
am,
your case, you have to
my lord, I
substantiate.
am simply submitting the, what is the existing law of the land. Your lordship.
Please, before that, please submit on your locus standi.
Locus. I have got, because that property, that property which I acquired, my lord, that belongs to my father.
Have you stated that in your writ
Yes, yes,
petition?
my lord, yes, my
Please show
lord.
me, please show me.
Para 4, your lordship, kindly.
Paragraph?
Para 4 of my writ petition. Then subsequently, again. Para 2, my lord, what I stated. Para 3 also stated. Para 4 also. I did not suppress anything, my lord. Whatever records available with me, I made a submission.
May I counter my knowledge, friends? It is a mere statement coming on affidavit on oath. There is no document even till today to show his locus over that land.
No.
Let him show. And I will withdraw.
What you were telling?
No, here it
He
is.
appearing on behalf of my client, my lord, in that case, partition.
That
So
is relevant.
that is why, my lord, that
That
is
is not relevant.
I raised the objection, my lord, against his conduct. He cannot have, your lordship decided, they have produced the letter.
Whatever objection
He whether,
So please place your
I
case.
made a prayer, his case, his conduct should be referred to the bar council.
Start the hearing. Please place your case.
I will deal with it. Refer it.
Both the applications are being not pressed by you, isn't it?
Yeah.
Refer it.
Can 1 and can 2, you are not pressing both the applications.
Yeah, I can one regarding I taking my lord 2 days leave only.
For what?
For can 1 amendment.
Amendment already here.
One doesn't contain anything. Can 1 will not help you. You cannot amend a petition again.
No, that will not press, my lord, but I will take a fresh amendment petition, my lord.
My lord, the difficulty is, my lord.
My lord,
As of
amendment
date,
is not
my lord,
required. My expert submission, amendment is also not required.
My lord,
So in that case, please continue with your
Yes,
submission.
my lord, that is why your lordship
Want
will
to come
see
back with an amendment, let us start the hearing.
paragraph 1, 2, 3. I am reading, it is my case, my lord.
Yes, please start.
Paragraph 1, my lord, kindly see. Petitioner state that great Father Raja Prabhat Chandra Bora, Gauripur, Assam, original owner of the palace of Matiabag, known as Hawakana, and adjacent land comprising of more than 70 bighas within the Dhubri, Assam, along with the other properties situated in Calcutta. That is the partition suit. That Matiabag Palace, my lord, along with the other suit at Calcutta, Shillong, Lucknow, all suits are involved in that case. And that, my lord, that suit has been partially the decreed, but preliminary degree survey happened. Surveyor has stated in the report, I could not complete because final degree has not been passed in accordance with the law. Unless final degree is passed, I cannot allocate the land by demarcation meets and bounds. But under the section 22 or rule 18, it is mandatory. Until Supreme Court 1991 from till today, I held repeatedly, the partition suit, if final degree is not passed, no party has no right to any property. 91 Supreme Court, your lordship, 92, 98 Supreme Court. That is my case. So I have got, as soon as the degree is passed, Supreme Court trial, as soon as the preliminary degree passed, it means it is a joint property. There is no dispute regarding that. Supreme Court said that yes, it is itself is sufficient, that is a joint property. If it is a joint property or it is not partition, meets and bounds, how they will send the matter, section 52 of the Lease Pendants Act to come into operation, my lord. Here section 52 specifically bar the parties. No party in the suit can sell any party, any portion of the suit property anywhere. That has been communicated to the government. There, yes, suit is pending. Section 52 would come into operation. But they ignored that, my lord. Even after received that letter, my lord, they paid the money. If they paid the money, if their lordship, I am satisfied that, if your lordship on perusal of the report satisfied that it is a fair proceeding, I have no case. Your lordship. But if it is unfair, my lord, undeserved, my lord, award has been given, then I will seek before your lordship to exercise power 226 to neutralize the loss cost to the public money by recovery the proceeding. Your lordship will under 226 you will exercise the power. That is why I pay that also that amount that cannot be kept in their pocket. That amount I say so the proceeding itself, because your lordship call for the record of the proceeding. But proceeding, what proceeding says that he totally flouted the principles of law, transparency of law. Rather, they in the circuit of secretly they committed meeting. In the record.
Please show me the documents.
Yes. 36 to the your report. Meeting. 46, your lordship, serious 46. Here it is confidential. This is the first meeting.
Page 46
Page of the report.
of the
Report. They constituted committee might be ignoring the earlier committee, earlier report of the settlement officer. They constituted committee on 4/7/2022. Under that committee has proceeded to Dhubri Bungalow to hold a meeting connivingly with the private respondent number 30.
report of the fourth respondent.
The minor page R3, page 46 of the report of my lord. Report. Bulky volume, the report of the, submitted by the respondent number
8 to 13.
Deputy Commissioner. 1 to 7 submitted the report. That is my lord, district magistrate of Dhubri
It
submitted
is
the
respondent
report.
number 4's report.
With a video.
That report. Yes. Yes.
Have you got your lordship? That is your lordship. Kindly see.
Page.
Page 46.
Page 46.
Annexure R3.
R3.
Yes.
Your lordship, this is the first meeting by this district magistrate. R3. minutes of the meeting in connection with the takeover of Matiabai Gauripur held on 25th August 1922 at Circuit House. In top, my lord, confidential. And your lordship will kindly see what they discuss in that meeting. What Central Act says that they, my lord, publication should be made in the newspaper, even in my website. All publications should be made. It is the Central Act. There is the guidelines, provision. Unless those provisions are fulfilled of the Central Act, all will, proceeding will be barred. Your lordship will find how they hold the meeting secretly. You see, section 5.
My lord, these are not under challenge. my
No,
lord.
no. What are the, how can I challenge? You confuse. My lord, we sought for document. RTI, I got 3 documents. That is why I come. Only 3 documents applied
Subsequent document.
on RTI.
Subsequently filed.
And they subsequently, as per your lordship direction, they are kind enough to produce all documents.
Confidential disclosed. Section 5.
And section 15, then, my lord, without hearing, landowners, interested persons, none can be deprived from hearing. These are the confidential. Whether confidential is allowed. The first question, my lord, I am is it whether confidential proceeding is allowed in the acquisition proceeding. Public hearing is mandatory. Well, then my lordship will see that I made a representation. My lord, what I did, your lordship will find they annexed it. Our TT 74. 74, my lord. But 17 October 2022. Your lordship kindly see page 75 R9. They produce it, my letter, my lord.
Yes, 75.
Page 75 of the report.
Of the same report,
Yes,
My lord.
page 75.
They produce it, my lord.
It includes our representation.
Our representations. Still, if my representation received, my lord, how they proceed to make payment on 10/10 without giving any opportunity me heard?
201, page 200.
Then
Your lordship kindly turns to page 201.
201, my.
Two hundred and one?
201. It is their record, my lord.
150.
It is the order sheet. They produce it.
201, yes.
Yes, my lord. Your lordship, this is order sheet number page 2, 8/12/2022,
yes.
that order. Whereas the government in Assam in Center has formed a negotiation and purchase committee for purchase and transfer of Matiabag Palace and transfer of Matiabag will government notification RL1 dated as the. That is the committee, that document is the constitutional committee document not produced before the lordship. They constituted by notification, gazette notification, that committee. My lord. Then your lordship come to second paragraph. Whereas the above committee in its function, under the right to fair compensation and transparency land rehabilitation and reimbursement act 2013, and sought report from the circle officers. Then, my lord, regarding details of which by Mohol and Astral Gauripur Majuda, which the circle officer reported. That is the dark. That is the circle report by my lord. It is the report they produce here, your lordship, is the as per directions of the committee of in the circular house. Circular, my lord, meeting was held on 25th and direction was given to the circle officer on 25th. He produced the report on 26th. That is not the report, which is produced under the provisions of this act, Central Act. How, if they started, my lord, that way they started the function under the act. Under what provision they will come in to defy that section, that act, Central Act. Then what they did, my lord, they certain difficulties are found. A report has come. There, my client has got a share. Then there is very difficult. to make payment to those persons. Unauthorized persons, they have no right to sell the property due to pendency of the suit. Then what they did, they passed one malicious order, my lord governor. Like a simple order, my lord, regarding acquisition of land, 7/3/1920. Annexure, your lordship, they produced it.
Annexure?
Yes. Then in that case, in this resolution, my
Annexure?
Page 202, the next page.
Next page.
They have considered the representation in the particular order.
that is my last representation, my lord.
Second paragraph, whereas 17th of motion petition. Administrative suit pending.
I mean, they himself admitted the pendency of the suit is pending. 9 such cases pending before the Honorable High Court. If it is Honorable High Court, it is a bona fide act on the part of the government or a person to take the disputed property, which is still final degree is passed.
No, pending.
Whether they can, where the no final degree is passed. And final degree is also, my lord, commission report is also incomplete. Commission report has stated. Your lordship will kindly see what commission report says, page 1,
Page 111.
111 of the report, my lord.
111 and 113. 111 and 113.
My lord,
111?
my lord, kindly come to the page, please see the page 95 of the report. Page 95.
Page 95.
Page 95. Page 95 of the report, my lord. 14, middle portion, my lord. Your lordship will find that LHS material with compounds comprising of area 75 bigas, thereafter is maybe above mentioned by the special reference. That is the subject matter of the commissioner, my lord. I mentioned in the para 1 of my petition. Well, that is the subject matter of the petition. Then your lordship kindly come to page 91, 111.
Page?
111. 111. Your lordship is a clause 3. What is stated, commissioner? My lord, that is incomplete report. It is stated, commissioner, what is stated.
Hundred and 11, yes.
111, my lord. 111, my lord, clause 2. Clear, clause 3, middle portion, my lord. It is not possible to effect partition of the land, my lord. You lordship kindly see. It is not possible to effect the partition of the land or comprise in the decree until possession thereof is obtained. As such, the partition of this plot of land has already left out until possession thereof is secured. And share of the parties on partitions thereof when made would be as was mentioned in the clause 3. That is the partition so that he give the
Page 113.
then
In 113.
your lordship see then 13.
113.
Then please 113, middle portion, my lord.
1-3.
Again he stated, I have not therefore effected partition of this suit property, which is not partitionable or sold at the same, as I have leave the same to the dealt with a later stage of this proceeding, or the court may direct the shares of the partition thereof in the also proceed land will be made as per mention in the clause. He specified preliminary decree. What preliminary decree, my lord, your lordship? See, preliminary decree is not a decree in the eyes of law. It is not executive decree. Preliminary decree in the partition suit. Preliminary decree in the partition suit. It is merely, my lord, admission of the joint property and share of the party. That is the preliminary decree. Unless final decree is passed, meets and bounds, no party has acquired any right to the property. In the 19, I will be able to show one judgment of Delhi High Court, similar question. In that case, possession was delivered and partition property. They claim, yeah, as per agreement, after the partition degree, we got possession. They similar, my lord. So they say no. You have no right to take possession because it is ineffective. Your deed, if it is done during the pendency of the suit, deed will be ineffective till final degree is passed. He cannot claim any right to the property. Third party can purchase. Party during the pendency of the suit. There is no bar, absolute bar. But Supreme Court said, yes, you have right to purchase, but you cannot get the fruits of the decree unless final decree is passed. So these documents, the Assam government, what is that document? It will be operative only if it is a valid purchase. Then it will be operative after final degree passed in this case, because this property is a part of that suit. They cannot ignore it. That is admitted on record. Then your lordship will kindly see what they did. Then what they did agreement after that, page 18. It petition page 18. 80, my lord.
80. This was the 80.
That is when I make a RTI at my petition. I approached them. I visited the respondent number 4 district magistrate any occasions. He did not pay. What he did, then they wrote to me after the receipt of my RTI application that with reference to above, I would inform you that as per government Assam decision 7/10/10 amount of the 15 lakh is going to be released on author. If it is fair, my lord, then I have no case. If it is not fair, then I will press before your lordship will exercise power 226 to neutralize the loss of the government, and they should be asked to deposit the money before the honorable court till finalization of this writ petition, my lord. Because then I have no right. Because Supreme Court, if there are undeserved and unfair grant is given to any party by the government authority, my lord, that should be recovered by under section 44 of the Civil Procedure Code. And that power is also with honorable court under 226. This is the Supreme Court judgment. So my prayer is that, my lord, whole proceeding for very beginning, my lord, this order that is 17 RKD, it is also hit by section 254 and 274. Doctor repugnancy, inconsistency. 274 says, if any law made by the state government and it is found inconsistent with the central government, law of the central government will prevail. There is no dispute regarding that. And they cannot overlook that, my lord. So when they overlook this, they started proceeding. Let them proceed according to this, under this law. What is the bar? Be fair. We shall contest. In this case, we have no bar to take the property in accordance with the law. Why you adopted an unfair procedure, confidential procedure, without giving any opportunity being heard? When I made several representations, how my right is gone? Fair procedure, fair hearing, fair investigation is a constitutional right of a party. Hey Lord, 1963 Supreme Court one service matter, my lord, I already saw, my lord, says if unfairness is shown by the anybody court need not go to other point. At once that should be set aside, thrown out. Because fairness procedure is an absolute right of the citizen, individual right of the citizen. But that cannot be denied. So I have come before your lordship to protect my right. Right has been given under section 52 of the respondents of the case, section 52, Partition Act. Also, partition also does not permit them to sell any property until partition is given. So I have come for protection of my right to property because I have got share until it is joint property, ancestral property. Respondent number 13 to 8 to 13. It is there not the father's ancestral property. It is the ancestral property of the how he donates the property in favor of the son before partition. How they manipulated it. They stated that, my lord, that is a will has been prohibited. What way will prohibit? The probate court will not see the entitlement. Title will not decide the probate court. Or civil court will see, looked into whether it is competent, he was competent or not on the date of execution. Party must be, civil court must be satisfied that on that day it was validly competent. He is competent. to execute the will. So several questions are involved here, my lord, details hearing. Let them come with a fresh evidence. Unfairly in this way, my lord, under this guy, under the order of the higher authority, or your lordship, fine for the order. What I saw in the meeting, chief minister was present. I do not bring all these things, my lord. Because he is a constitutional, my lord, statutory functioning authority, distinguished. He should not be influenced by any person. He should follow the law. Law has been. Why you adopted a law in particular manner, you cannot divert the same to for other purpose. That itself shows that is a malefic intention. There is no, when the central law is there, you adopted the procedure.
That's all.
So that is my submission, my preliminary submission, my lord.
Preliminary submission. Make your entire.
No,
submission.
after there, my
You'll be given an opportunity to reply, definitely. Yes, who will choose to reply first?
My lord, Lordship may kindly come to page 201, my lord, the deputy commissioner's report, my lord, the order passed by the deputy commissioner, my lord. He has dealt with every aspect, my lord.
One of your report?
My lord. I'll read the entire order, my lord, then there will be clarity. May I read, my lord? Whereas the government of Assam in the cultural department had formed a negotiation and purchasing committee for purchase and transfer of Matiabag Palace and transfer of Matiabag Palace, Gauripur by government notification number so and so, so and so. Whereas the above committee in its function under the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 sought report from the Circle Officer Gauripur Revenue Circle regarding details of land on which Hawa Mahal of the erstwhile Gauripur Zamindari state, to which the circle officer reported that the Hawa Mahal stood on 5 number of dags, namely these are the dags, my lord, and the patta number so and so, land measuring total 12 biga 3 katas 18 lachas. Further, it was also mentioned along with the chitta copies in that pattas of these dags are follows. So we are concerned about these pattas of land, my lord, and these are the names in the revenue record. They are the pattas, my lord. These things have not been challenged by them at any point of time. Their ownership. Well, revenue record speaks about the ownership of these pattadas, my lord, and they have acquired this right by virtue of the will and the probate and the court commissioner's report.
But they are co-sharers, isn't it?
They are not nobody in this pattas. They are nobody.
No, these patta holders are supposedly co-sharers of the property.
These patta holders are the sons of one of the, who has executed a will. I'll share my lord, can I hand over this family genealogy, my lord? How the right has come to them?
Please give a copy to the petitioner.
Before that, may I read the report first, my lord? Then I'll come to this.
Yes, please. Yes.
Yeah. Whereas it is also to be mentioned that Padma Shri Pratima Pandey Barua, in whose name the government of Assam has planned a restored museum, is also a daughter of late Kritish Barua. Whereas the culture department, as per the reports of the purchase committee, also informed the undersigned that rupees 15 crores has been sanctioned for acquisition of land in Matiabag on October 2022. Whereas on 17th October, a prayer petition was received in this office from Srimati Mausami Barua, the petitioner here in my lord, so and so, who is also another son of Raja Prabhat Chandra Barua. In her petition, Srimati Mausumi Barua has stated that she came to know about the purchase of the Hawa Mahal by the government from media reports, and that the sons of Late Praktish Barua had gone ahead with the negotiation without settling their family property dispute. Srimati Mausumi Barua mentioned about a decree of by consent passed by the Honorable Kolkata High Court dated 28 August 1963 in the administrative suit of so and so, so and so. Whereas on the original decree, the terms of settlement, it is seen that on page 2 of the first schedule of the land under Khatian number so and so, Dag number so and so, the total land area 26 vigor 3 katas and 17 lessas is given under the joint names of Kumar Prakritish Chandra Barua. We are the sons of the Kumar, they are the private respondents are the sons of Kumar Prakritish Chandra Barua, my lord. There are three sons, my lord. Whereas the sons of late Prakritish Barua, represented by Sri Prabir Barua, were sent a notice regarding the terms of settlement and adherence thereof on 30/11/2022.
So this is the preliminary decree that is being talked about in this
My lord.
report.
My lord. In response, Sri Prabir Barua submitted on 5/12/2022 a copy of the return of the commissioners of partition dated 28/5/77 of Sri Patul Chandra Datta, Advocate Commissioner appointed under order dated so and so with annexures filed on 1st December 1989. This report filed is also out of the original administrative suit number 993 of 1960 in the Honorable Kolkata High Court. Whereas on perusal of the above return in page number 6 in second schedule, it is mentioned under portion of Rajbari and compound at Gauripur and Matiabag Palace and compounded allotted to Kumar Prakritish Chandra Barua. Mention has been made of Khatian number 365 or Dag number 560, which corresponds to the post resettlement now Dag number 11. These are the 5 Dag numbers, which are under consideration for the purpose of this acquisition by the government. Whereas another complaint received from one Kanchanmala Barua, who reportedly is the daughter of late Prakritish Barua, from a different wife. Whereas in response to claim, Prabir Barua submitted will executed by late Prakritish Barua and probated by the Honorable District Judge, which mentions that on inheritance of all landed property at Matiabag, only the 4 sons, namely Pradeep Barua, Prabir Barua, Pradut Barua, and Pritam Barua will get shares and no one else, and no daughters. May I pause here, brother? Pratima Barua, late Pratima Pandey Barua, is also one of the daughter of Prakritish Barua, in whose name that museum government want to promote. Hence, from the above 2 documents, it is established beyond doubt that the aforementioned Dags at Matiabag, Gauripur, the 4 sons of late Prakritish Chandra Barua, are the rightful beneficiaries of the compensation. The 2 complaints received do not stand at least in context of purchase of Hawa Mahal and the payment of the compensation thereof to the above intended beneficiaries. In view of the above documents provided and in compliance with the distribution of landed property of the Gauripur estate in the original administrative suit number 993 of passed by the Honorable Kolkata High Court, it is hence concluded that for the acquisition of Dag number so and so, Government of Assam, the recipients of the compensation amount will be the 4 sons, late Prakritish Barua, Pradeep Barua, this so and so, according to their shares on the Dags. Further, if the sons of the late Prakritish Barua wish to share some compensation, same compensation amount with their sisters, will be according to their agreed settlement and affidavit is submitted. Well, that is how the right, we the being government, we have purchased the land from the Pattadas, my lord. And Lordship may kindly come to page 131, my lord.
Admittedly, the final decree is pending.
Final decree is pending, my lord.
So could the transfer have happened during pendency of the final decree?
Because it has been partitioned by way of will, my lord. Already it has been partitioned, and that is Court Commission's report also to that regard, my lord. Court Commission's report is there. Page 131 is the Court Commission's report, my lord. Lords may kindly see page 131, my lord. Lords may kindly see page.
Initially, there was a will.
There is a will.
Original owner. The partition suit is among the.
Partition suit is prior in time, my lord. 1960 is the partition suit, my lord. In that partition suit, my lord, there was a preliminary decree on the basis of the settlement, on the basis of the will, with the basis of the probate, my lord.
Preliminary decree on the basis of the probate.
There was a settlement, well, on the basis of.
What has happened?
Hmm.
Because in the partition suit, when the partition suit was pending, well, there was a initial terms of settlement between the parties.
Terms of settlement, my lord.
So in the terms of settlement, the parties arrived into a broad consensus. And the court, this honorable court, in order to effect partition, had appointed a commissioner.
Court commissioner.
And that commissioner, my lord, appointed by the court, my lord, had in fact, my lord, affected partition. And when the partition has been affected by way of return of the commissioner, which has been filed in the court, my lord, it is a part of the record of the partition suit. Partition has been affected in meets and bounds.
But
And
the final decree was not passed.
final decree was not. The final decree was not passed. And my lord, it has been partitioned in meets and bounds. Having my lord partitioned the property by way of meets and bounds, the portions of land, part and portions of the portions of land, my lord, devolved upon various persons, my lord. One of the persons is, my lord, the predecessor in interest of the beneficiary.
Executed a will.
Executor of the will.
He executed a will. And all these things happened, my lord, way back. Much water has flown in the meantime. They have not, my lord,
Challenged, they have not put-
anything. And nobody in the entire Barua family has come up before this honorable court at any point of time putting challenge to the entire procedure. And this is how, my lord, the things has happened. Lordship may kindly see, my lord, page 131 of the report. Lordship, page 131, Lordship will kindly see, my lord. Page 131 of the report.
Mathiabag Palace in Kampong.
Yes, 131.
131, Lordship will kindly come to, my lord, that clause number 2. It is in between, my lord, in the page.
Part 2, yes.
Yes, part 2. Mathiabag Palace compound Khatian number.
368, 5, 368. And we are
It has already been affected. Partition has already been affected.
Partition can be effected only by way of a final decree, sir.
Yes, but
Not by way of a surveyor's report.
Yes, but here, my lord, what has happened, everybody has accepted.
Consented,
They
everybody.
can accept the writ petitioner who has come at a later
So
stage.
there should have been a final decree upon acceptance.
Maybe, my
on
lord,
compromise?
Maybe.
Unless there is a final decree, could any of the co-sharers have dealt with the property?
Yes, they have dealt with the property.
That is the point that your lordship has rightly pointed out.
Could they have done that without a final decree?
All parties have done so, including the petitioners. And today the gun is being pointed at me that you can't do it. Let him put it on affidavit that he is not acted in terms of the preliminary decree and the commission of partition.
That's irrelevant in this matter.
No, because this is the point that is being raised, that I can't do it. I can't do it, so what is source for the goose is also source for the gander. I can't be held to ransom to say that you can't do it, but I can.
Is it your case that the petitioner has also done it?
Yes, I have written it in my report, in my affidavit. And not only have they acted in accordance with that, I have got documents to show that, which I will bring on record if necessary. They have, some of them have also acted in excess of their right. That's also in my report.
Is that relevant in this writ petition?
It is, my lord, it is relevant primarily because the petitioner are claiming a right over the land or portion of the land which is
I'll
mine.
take it fixed for my lord trial.
You'll have a right to reply, sir.
Just a minute,
You'll have a right to reply.
You've had your say.
Yes, continue, please.
My lord, kindly come to page 153, my lord. 153. 153. Yeah. That is it. In this circumstance, para 2, my lord, clause 4. In these circumstances, I effected partition of the Rajbat and the Mathiabag Palace amongst the parties entitled thereto by respectively allotting to Kumar Prakritish Chandra Borua the portion of the Rajbati and Mathiabag Palace fully described in the part 1 of the second schedule thereto and shown in the annexed plans and colored red therein. Then lordship may kind to come to the last para, my lord. The parties agreed and I hereby direct that so far as the Rajbat and the Mathiabag Palace is concerned, there would be right preemption amongst the parties. That is to say, if any of the parties desire to sell or grant long lease or any portion of the Rajbati Madhyabag Palace hereby allotted to them respectively, such party shall be bound to give written notice to other co-owners of his intention to do so. Then Lordship may kindly come to page 171, my lord.
This is the report of the surveyor, isn't it?
Commissioners of partition, my lord. Commissioner of partitions report, my lord.
Can the partition commissioner give such directions at all?
My lord,
Direction for preemption, liberty to preempt.
my lord, that was at that point of time, my lord.
It can only affect partition, isn't it? By meets and bounds, nothing more than that.
My lord.
Well,
That
continue.
is why, effectively, that is what he has done, my lord. Then Lordship may kindly come to page 171, my lord, in that very report. So that is a schedule, my lord. Page 171. Number 3, my lord. Madhyabag Palace at Gauripur with adjoining buildings with a land comprising an area of 78 bighas, 3 kathas, 17 acres. The said property has been recorded in the last cadastral survey under the following khatiyans in Mauza, Gauripur town, part 2, police station so and so. Khatiyan number so and so 365, dag number 560 and 562. Total area so 26 bigha, 3 lacha, in whose name recorded joint name of Kumar Praktish Chandra Borwa, Pranavesh Chandra Borwa, and Srimati Madhulita Borwa, and 3 sons. So, my lord, then Lordship may kindly come to page 194, my lord. Now, Kumar Prakritish Chandra Borwa executed a will in
194.
Yeah, this is the landed property, land measuring 13 bighas, 11 1 katha and 14 lecha, covered by dag number 560, Khatiyan number 365, patta number 25. Yeah. Page number 88. Lordship may kindly come to page number 88 then, my lord.
88.
88, my lord. 88 on complaint of Mausumi Borwa, na? This is on complaint of Mausumi Borwa, the petitioner herein. The reply was given by the Pattadas, my lord. We, the undersigned, have the honor to bring to you that because Deputy Commissioner asked for a reply from these Pattadas, my lord, on the complaint lodged by them. That they are the private respondents herein, my lord. We, the undersigned, have the honor to bring to your kind notice that for the purpose of purchase acquisition of Hawa Mahal at Madhyabag Gauripur, 2 documents need to be considered, which would determine the beneficiaries in and inheritors of not only the Hawa Mahal but the entire property of Gauripur Zabidari estate of late Raja Prabhat Chandra Borwa. These documents are namely return of the Commission of Partition dated so and so. These documents was filed on 1st December 1989. This return is filed out of the original administrative suit number 993 of 1960, Honorable Kolkata High Court, and further elaborates the distribution of gold and other landed properties. This clearly seen that the portion of the Rajbari and compound at Gauripur and Madhyabag and compound is allotted to our father late Kumar Prakritish Chandra Borwa. On page number 6, it is clearly seen that the land measuring 13 bigha, 11 katha and 14 lecha pre-settlement of old dag number 560 and Khatiyan number 365 has been assigned to late Prakritish Chandra Borwa. This is the land which, according to official record, corresponds to the 5 number of dags 1184, so and so, that is to be acquired by the government of Assam. Will of our father, second document, my lord, will of our father late Prakritish Chandra Borwa, a grant of probate by the district judge Dhubri in TS case number so and so. In this will, our father, which is duly probated, it has been clearly mentioned that the Madhyabag Palace with its compound and appertaining land will be distributed in 4 equal parts and distributed amongst his 4 sons, Pradeep Kumar Borwa, Prabir Kumar Borwa, Padut Kumar Borwa, and Pritam Kumar Borwa. And apart from these 4 persons, no other person will receive any share of the landed property at Madhyabag. Thus, we make a humble prayer through support of the above mentioned document that welcoming the decision of the government of Assam, we 4 sons, late so and so, with along with our ancestral home, so that it can be preserved in the name of our eldest sister, Padma Shri Pratima Pandey Borwa, who is not only the jewel of our family, but of the entire state. We submit copies of. So that is the reply by the Pattadas, my lord, on her complaint. My lord, these are the factual submission, my lord. And apart from factual submission, there is a legal submission, my lord. These are all disputed property disputes and all. Property disputes cannot be adjudicated by a writ petition, my lord. That is what is my humble submission. Supreme Court judgment is
Is
also.
there really any property dispute? There is no property.
This is property dispute.
The legal question which arises is during pendency of a partition suit,
My lord,
could one of the co-sharers have executed this will?
my lord, they have not questioned that will, that they have not questioned the probate. They have not brought those documents before this honorable court, my lord. At the time of filing a writ petition, they have suppressed. On suppression count alone, that writ petition should have been thrown, my lord.
This is your report, sir.
My lord, my report, but that is a part of the trial court record, my lord. That is trial court because before the.
Petitioner has challenged the operation altogether.
My lord, they have not challenged. See, if at all they are aggrieved by the subsequent proceeding by the deputy commissioner, they could have filed appropriate application before the suit only, my lord. Why writ court, my lord? They could have filed an application for necessary action, my lord, from the before the trial court, my lord.
Is that all your submission?
My lord, moreover, the property is located in Assam, my lord. So territorial jurisdiction part I have said, my lord. So what if I consider, my lord?
The jurisdiction is settled now, sir.
My lord.
The writ court can deal with it.
But this judgment can I have over, my lord? That's what is my submission, my lord.
The relevant paragraph?
Paragraph 15, my lord.
Paragraph?
15, 1-5.
Judgment.
Judgment for copy.
Copy.
No spare. I don't have spare copies. I don't have spare copies, sir.
That is not a pair.
You can 2014 6 SCC 508. 2014 6 SCC 508.
This is with regard to a landlord-tenant dispute and a dispute of a private
lord,
individual.
My lord,
How is it applicable in this case?
my lord,
Where is the territory?
paragraph 15, paragraph
Yes,
15.
please.
My lord.
Yes. Paragraph 15.
Petition under 226 of Article 227 of the Constitution of India can neither be entertained to decide the landlord tenant dispute, nor it is maintained like ideas, my lord, to
This is not the case here.
property related disputes, if at all there is. So writ court is not competent to adjudicate, my lord. Suit is already pending, my lord. They could have filed any application before the suit court, my lord, instead of coming to the writ court.
You are challenging territorial jurisdiction, sir. So where is the territorial jurisdiction challenged in this authority that you are citing?
Territorial jurisdiction, my lord. Right now, I am not having any authority. I'll file it.
This authority doesn't help you. in this.
Because property is located in Assam. That's for sure, my lord. That is
Admitted.
yes, admitted, my lord. And
Only one submission with lordship's gracious permission, but adding to the submissions of my learned senior colleague. But the suit, my lord, started in the year 1963. In the year 1970.
The partition suit.
60. 1960, my lord.
Precisely in the 60s. So it is in the 1960s. Then in the year 1997, this commissioner of partition has, my lord, rightly wrongly, he has affected partition. All the parties to the, my lord, suit has acted upon it. In the meantime, my lord, in the year 1997, the learned district judge out there in Dhubri, Assam, has granted probate on the strength of a will executed by the predecessor in interest of the persons who are the beneficiaries herein. Neither, my lord, in the year 1977 nor in the year 1987 or thereafter, my lord, this petitioner, or for that matter, the predecessor in interest of the petitioner has chosen to challenge it.
Was it within the knowledge of the petitioner? Can you substantiate? Please substantiate that.
Yes, it was within the knowledge.
Please substantiate that, sir.
How will you
That
substantiate?
the petitioner had knowledge all throughout.
Yes, so because my lord, in the process of acquisition, when this property has been acquired, petitioner, my lord, had filed a
So
complaint.
these are between private parties interstate. Petitioner was not involved.
No, no, she has
So how
filed a
did the
complaint.
petitioner have
She has
knowledge?
filed a complaint before the deputy commissioner. no?
She has filed a complaint, and my lord, that
Uh,
complaint has been addressed to that. That is what my lord.
I have read out that.
That
transpired.
complaint is only after the alleged transfer, isn't it?
Yes.
That
Not
was
al-
when the petitioner had knowledge.
No, no, prior to transfer, my lord.
Prior to also transfer. Because
During
my
the
lord,
proceeding, then during the
because-
proceeding.
Because it is the.
That is when the petitioner had knowledge.
Now, my lord,
Petitioner was not supposed to have knowledge about the will
because my
or
lord,
the probate.
Because they are parties before the suit, my lord, definitely they have knowledge of. Because
because my lord, the petitioner here is claiming her right, my lord, under the predecessor interest.
Have
Her
you
predecessor
submitted
interest.
the documents of the suit?
No, my
suit,
lord,
we have no
are not a
record.
party,
We
my
have not, we are not party, we have no record of the suit, my lord. So we
So
not,
the
we are
humble
not.
submission at the end of the argument will be, my lord, this is a clear case of, my lord, waiver, estoppel and acquiescence. They are now estopped, my lord, from raising that plea, since they have acted upon.
So in that case, you have to show that the petitioner had knowledge all throughout
My lord, that, my
of
lord,
the alleged transfer.
yes, my
That-
lord, of course, my lord, we had a purchase, my lord, that.
I will clarify, my lord.
My learned friend will address my lord on that
I
issue.
will clarify that. So the petitioner-
Will you please take the microphone?
You come here. Come this way.
Your lordship had desired to know as to whether the petitioner had knowledge. She is a party to the partition suit. Her predecessor was a party to the suit.
No.
Over a period,
Yes.
over a period of time, substitutions have taken place. So she is fully aware as to what is happening. It's not that she's ignorant of anything. She's fully conscious of what is happening. Today, she can't come up and say that I don't know.
She is aware of the partition suit. She is aware of the surveyor's report also.
Even the will, because that has been mentioned, it's been taken care of. The suit is appearing on the 20th of this month before the coordinate bench. She's aware of it. It's brought on record.
In that case, will you come back with the documents of the suit to show that
You know, they're very, very
the
bulky.
petitioner is aware?
They're
the
extreme.
The relevant documents?
I'm not going to document a will that expiration. Not in one
You
of,
can only show that this point has been raised in the
yes,
suit
yes.
also.
If your lordship permits, then what I can do is I can probably bring the necessary GA by virtue of which we had filed in the suit, bringing the fact of the will being to the knowledge. She's aware of it. And she has responded to that. There is a reply to that GA.
And this transfer is also mentioned in the suit?
Yes, yes. My lord, this transfer is emanating from the fact today, all parties to the suit are aware of the terms of settlement, the commissioner of partition, that report. All parties, including the petitioner, have acted on the basis of that. Every single one of them, including my clients, they have all acted on it.
Even if it's dehorsed the law, can it?
Even if it be
accepted?
dehorsed the law, rightly or wrongly, as your lordship says, for whatever be the reason, a commissioner of partition was appointed by the court. In terms of the terms of settlement, which was mutually agreed between the parties, he drew up a preliminary decree, a commissioner of partition report. All parties agreed to that partition and have proceeded further.
By themselves, not approaching the court.
No, by themselves. By themselves, they have
The
acted.
matter was pending before the court.
While the matter is pending, even today, the matter is pending. As your lordship has said, rightly or wrongly, all parties, including my clients, have proceeded. The only one aspect that is remaining in the entire gamut of assets is one ancestral hookah, which is actually a very, shall we say, very, very precious hookah. That is the only item that remains. All other items, including gold coins and precious gold coins, have been partitioned amicably between all the parties, including the petitioner. She has proceeded and she has brought her own name onto the records of the government. Now, the government will not act suo motu on that. It has to be on an application by somebody. That please kindly bring my name onto the records. How did that come on record?
Please show me some document to show that the petitioner had knowledge of this also.
Of the?
The transfer, the will.
Yes, that is all part of the trial court suit.
Says that upon having knowledge of the transfer, which he challenges in this writ petition,
Yes.
he has come up before the writ court.
No, the transfer is a separate issue. All I'm saying is, first of all, my lord, I,
Minutes from the will.
it begins from the commission of partition status. Why I'm saying so, my lord, let me clarify. I am a rightful or wrongful owner of a plot of land. Some interloper comes in and says to the court that that land belongs to me. So kindly stay your hands and kindly stay all proceedings relating to that land. When that person appears entrance in the court, is it not his fundamental duty to first establish his right over that land vis-a-vis me? I have got documents on record to show my right. Not a single document has been brought by them on the record. To counter that allegation
Are you denying her title in respect
Yes.
of the joint property?
of that part of
Please
the
forget about the surveyor's report because
of
I'm not.
yes, yeah, I am denying her title over that part of the property which is under challenge.
That part is you are meaning the partition property,
That's right.
which has not been affected by way of a decree of a court.
By way of a
Decree of a court.
very well, may not be.
So it is still joint.
No, it is not joined. That is exactly where I'm
The
joining issue.
surveyor's report cannot partition a property.
But the surveyor has been appointed by virtue of an order of the court.
But where is the final order?
The final order may not come. My learned friend has taken a point of section 52. What does section 52 say? Section 52 says that I can't alienate or transfer the property during the pendency of the suit. But per se, that transfer or alienation is not void. It is voidable. Voidable at the option of the purchaser. What does it say? That should the seller succeed in the title suit relating to that land, the title is good. Otherwise not. Fair enough. There's no dispute about that. But to stand up and say that by virtue of section 52, you are completely barred, that is not the law.
Will you continue some other day?
Well, I'm ready to do it today also.
We are past.
No, up 2 o'clock.
2 o'clock, I have some other matters.
Okay. Well, they will have to give a date because I'm in town. They who come out from outstation.
According to your convenience. When can you? Yes.
Well, at the earliest, subject to whatever, suggest a date, please.
Since you'll be coming from Assam, so
Yes.
when will it be convenient for you, sir?
Milord, on the next date, whichever your date may be fixed, Milord, I will take 3 or 4 points of demo first. And thereafter, if I succeed in those, I need not get into the merits of the matter. Otherwise, I'll get into the merits.
Also, we have it on 27th of June.
27th of June, right?
27th June. 27th.
Or learned counsels for the parties. Let the matter appear under the same heading for further consideration on 27th of June.
27th of June.
27th.
My other side is here. I don't know what I have mentioned on morning, my lord. My interim order will be expected today, my lord. So
You mentioned
no, my lord. One thing, my lord. Kindly fix this matter because kindly fix this matter tomorrow or day after tomorrow at the peak.
It will be
In the
fixed
meantime, my interim order can be extended. My other side is there. My lord.
tomorrow for extension of interim order only to be mentioned.
I know only in the
No, my lord.
Yeah, tomorrow.
My interim order can be extended tomorrow, day after tomorrow.
Tomorrow it will be fixed as to be mentioned for extension of interim order.
My interim order will be expired tomorrow.
My lord, till today. But tomorrow nothing will happen. My lord, tomorrow if your lordship
It is
fix the
still
matter.
today. Tomorrow 10:30
My interim order will be.
to be mentioned.
Great.
It's a base. I need not say anything. No, Milord, I just expressed what I would do on the next day. I will take my points of demo and then get it.
Continue.
Very. Obliged.
Be an actor.
In case anyone has some urgent matter.
No. That is why I inform.
So no one is going to.
I think, my lord,
No urgent matter.
no urgent matter, my lord.
Petitioner কেউ তো নেই।
Petitioner একজনই আছে।
Unless anybody mention.
One petitioner representing everyone.
There's a sufficient representation for the day.
Yes.
Only one thing, my lord, item number 67, if your lordship kindly take it up on Wednesday, my lord, because my senior will not be present, my lord, Mr.
Item number?
67. Next 14th of June, if your lordship kindly take it up.
$67 to date দিয়ে দিন। Wednesday, পরের বুধবার। 14th listed দেখে ব্র্যাকেটে 14th, please inform the other side.
My lord, we shall.
Other matters would be written as.
Yes. Only not today.
Great.
ছয় না? ছয়টা একবার দেখো। ছয়?
ছয় ওদিকে হবে না।
ভাই ছয়তে তোমাদের দুটো অব্দি চলবে। আর হবে? বলছে বুঝবে না, জানে।
একবার দেখে নাও, দেখে নাও।
তখন কি? তখন নন্দী আমার কাছে খবর এলো। সেটা তো আসল
সেটাই তো বলছি কেন দিচ্ছ হলো, কেন
They have available in the. You can just send it to me. That is just fixed on 14.
যেদিন যেটা বলেন 12 নম্বর থেকে তুলে নিয়ে থাকে 12 করতো না, আমি একটা লোক রাজনীতি করে বলে nobody appear, no? কারণ ওরা জয়মালের ঘর থেকে আসতে পারছে না, জয়মালের টাইম দেয় না, ও বাড়ি থেকে একদম বসছিল।
ওটা দরকারও ছিল।
পূর্ণচন্দ্র দাস নাকি
চিত্তরঞ্জন দাস।
চিত্তরঞ্জন দাস,
না ওটা দরকারও ছিল। ওখানে সমস্ত ক্রিমিনাল বেঞ্চ গুলো ওইখানে।
না
তাই যদি বলো
তাহলে তো অপো তো ওখানে বসে আছে।
না ওটাও দরকার নেই।
অপো কেন ওখানে বসে আছে? কৌশিক চাঁদ রাজা বসু চৌধুরী এখানে বসে রয়েছে।
আর কি হলো, কত কষ্ট করে রোদ্দুরে গিয়ে দেখলাম যে পিটিশনারের লইয়া নেই, টাইম হয়ে গেল। আর রোদের জল ঝরে যাচ্ছে। কৌশিক চন্দ্র কেন এই বাড়িতে আসছে? তোমাদের মধ্যে কয়েকজন পাশে তো 36-এও তাই হলো। হ্যাঁ 36-এও তাই হলো।
আর ওরা বুঝিয়ে নিয়েছে ওই ঘর
36টা তো অরিজিনাল সাইজ। 36টা ঠিক আছে, অরিজিনাল সাইজ অরিজিনাল সাইজ সব ঠিক আছে। কমার্শিয়াল পেজ তখন তো অনেকদিন ধরে একটা হচ্ছে ওই সেই কালিয়াগঞ্জের সেই মেয়েটি জলে ডুবে ইয়ে হওয়ার পর দিন পাওয়া গেল, রেপ করেছিল। হ্যাঁ ওইটা গেল, তার সঙ্গে প্রথম আরো অনেক 5-9 এরকম সব রেজিস্টার আছে। তারপরে তোমার যে কোনো 36 নম্বর কোর্টে ছিল, সেখানে এখানে 6 আমার 11 নম্বর। আজকে হলো আজকে যাই না হলো, সেখানে টুপিয়ে অনেক ধরে যে ঘন্টা করে টুপিয়ে কাজ ছিল। আজকে তো টুপিয়ে হলো না। হলো না বলে দুঃখ নেই, প্রবলেমটা হবে তো কাল থেকে আমার এই মামলাগুলো প্লাস কালকের গুলো যোগ হবে, তখন আমি কোথায় যাবো?
দেবাংশু আবার দেবাংশুর কোড নিয়ে আবার একটা ঝামেলা হয়। হ্যাঁ, দেবাংশুর কোড নিয়ে আবার একটা ঝামেলা হয়। তো সরালো তো ঝামেলা হয়ে সরালো, তাহলে তো কেউ সরালো তো ঝামেলা হওয়ার জন্য। হ্যাঁ? মৌসুমিও তাই, মৌসুমির এগেন্স্ট তো কমপ্লেন গেছে। না না, অ্যাপিলেট সাইড অরিজিনাল সাইডে দিতে পারে। বছর দিন না ওটা তুমি কি করলে হবে? না যেখানে ভালো কথা ভালো কথা
আমি কি বলছিলাম,
আমাদের হাইকোর্টের সব মাল করতে দেয়। হ্যাঁ আমি টুইটি করে দেওয়ার চেষ্টা করেছি মাঝে মাঝে না না ওরকম তো না, এরকম করে বলে না ইয়েস প্রিন্সারকে পর্যন্ত আরম্ভ করে আমি খুব সিরিয়াস ওয়ে করছি মজা করে সবাই জানে আমাকে দেখলে একটু মজা কিন্তু আজকের দিনে নর্মালি এটাও ঘটে রং অর্ডার দেয় শুধু আর্ট 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 হবে ট্রেডিং একটু আর্ট ছোট্ট করে ছোট্ট করে বলা আসল জায়গা আর একটু বোল্ডনেস এই সমস্ত লোকেদের দিনের পর দিনকে টাইম দিয়ে যাচ্ছি আমরা সুযোগটা একটা ভালো লোক পেয়ে লম্বা একটা জানি সব থেকে সমস্যা হয় আমার সমস্যা হয় আমার কালকে দেখলাম পয়েন্ট হচ্ছে এই জায়গাটা ছোট্ট একটা পয়েন্ট কি আমার বাড়ি settlement of the agreement. Partially, ওর কাছে লেখা আছে প্রসিডিউর হয়েছে পার্সিয়ালি ডিসির কাছ থেকে সার্টিফিকেট অফ তারপর থেকে আর কিছু করছে না এই চারটে সেন্টেন্সে বলা যায় এবং এই ও বললো কি কাইন্ডলি কাম টু মাই লর্ড ফার্স্ট অ্যানেক্সচারে কি আছে না ওটা হচ্ছে যে পারমিট কপি মাই ক্লায়েন্টস আর পারমিট হোল্ডার কেউ একদম তো ডিনাইও করছে না then also kindly come to next annexure এই করে 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 যখন ফিচার মানছি ছোট মোট অর্ডার দিতে হবে ভোটফল থেকে হাওড়া থেকে কাটতে চেয়েছো
থাকলে হয়ে যেত
তুমি হাওড়া থেকে ভোটফল চেয়েছো
আমার থেকে 9টা মামলা ধরে গেছে
লাস্ট উইকে লিবার্টি দিচ্ছে লিবার্টি তুমি একটা প্রেস করে করো এমন করবে কি পিটিশন ইয়ে হয়ে গেল ও চাইছে বরফল থেকে পারবার না কেউ না বিহারের মনে চলে এসছে বরফ পার্লামেন্টটা বরফল তো মহারাষ্ট্র নিজের রুটটাকে কাটে
আর রিপ্রেজেন্টেশনটা যাই বলা আছে ইট উইল বি কনসিডার ফ্রম x to y পয়েন্ট তোমার z পয়েন্ট সেটাই ওরা দেখবে দরকার নেই তো ভুলটা ভুলে যাবে
সেটা দশটা ভালো বলে ওরে বলে তুমি কি চেয়েছো পাসপোর্ট ছিল তুমি চলে গিয়েছিল
পাসপোর্টে তো
জলদি ছিল তোমার বিরাট কাউ ছিল
ছয় কি হলো ছয় বসবে না তো তাহলে চল চলে যাচ্ছে দিয়ে দিই চান করে যখন
জামা কাপড় জামা প্যান্ট
চান টান করার পরে তোমার শরীরটা দেবে না তারপরে কি হবে এসিটা চালিয়ে বসো এসিটা কাজ করতে পারি না বিলিভ সেই এসিটা চালাতে পদে একটু আসছে এসিটা তুমি কিছুতে কাজ করতে পারো সে হচ্ছে আর দেখছি একদম
খুব হালকা করে চালাও হালকা চালাও
এই বয়সে কোনো কিছুই বুঝেছি না সবই হালকা
সবই হালকা
যদিও যদি তুমি মেয়ের কাছে ঘুরে এলে হ্যাঁ তোমার মেয়ে আসছে 30 তারিখ গেলাম যেই বললো তোমরা আসবে তাহলে আমি যাবো যেই বললো তোমরা আসবে তাহলে আমি না খবরদার যাবো তুই আয় আমি অন্য কোনো না না তোমার থাকবে থাকবে বলেছে ওয়ার্ক ফ্রম হোম থাকবে মানে কি ওর দেখা পাবে না ওই যে 9:30 থেকে ও ঢুকে পড়বে ওর ঘরে ও তারপরে মাঝে মাঝে মায়ের কাছে করে খাবার দাবার করলে একবার এই করলে 8:30 9 পর্যন্ত দেখা পাবে ওরা তার শরীর
ঘুম থেকে উঠতেই বেলা করে চলো
গরমটা আমি তো কথাটা বুঝছি না যদিও ওরা এসে কপি করতে চায় বৃষ্টি হচ্ছে তো
চাদর দিয়ে রাত্রিবেলা এতটুকু 15 দিন ছিল চাদর দিয়ে বৃষ্টি যেদিন করে ব্যাস
চিরকালের ওই ও কোনোদিন হবে না। কারণ স্বাধীন হওয়ার আগে থেকে যাবে না, স্বাধীন জজ ওই কাবিন নোট তৈরি করে জানি লাস্ট জানি গেছে বহু বছর।
সপ্তাহে ফোন করে 4খানা রাখবেন।
সব থাকবেন
পাওয়ার ব্যাটন নেই, তার উপরে টাইটেল এর বেসিসে কোনো পাওয়ার টাইটেল ইয়ার করে ল করে, এটা তো ল। পাওয়ার ব্যাটনের ক্ষেত্রে তাই বলছি, পাওয়ার ব্যাটনিতে কোনো টাইটেল দেওয়া
টাইটেল কি করে হবে? পাওয়ার দেওয়া
না না, পাওয়ার ব্যাটরিতে পাওয়ারফুলটা মারা যাওয়ার পর
মারা যাওয়ার পর তো চলে গেছে। না
কমিশন আছে,
কমিশন আছে, কন্ট্রাক্ট অ্যাক্টে যেটা আছে,
কন্ট্রাক্ট অ্যাক্টে 100% কমিশন আছে।
যদি তোমার
অ্যাক্টে দেখো,
তুমি যেটা করতে তা ধরো যে কোনো তোমার এই প্রমোটারদের সঙ্গে ঠিক আছে, আমরা
তাহলে বুঝবি আমি ব্যবস্থা
ল্যান্ডও না পাওয়ার ব্যাপারটা নিশ্চিত যে আমার হয়ে তুমি এই কাজটা করবে। এবার ল্যান্ডওনার মারা এই কখনো এই ব্যাপারই থেকে যাবে, সেটা কন্ট্রাক্ট অ্যাক্ট অনুযায়ী থেকে যাবে।
অ্যাক্টে এখন যদি হয়ে যায়
তো সেকশন 170
108
না
130
আরে না রে
77
সেকশন 108 170 এখানে
কোনো ইন্টারেস্ট ক্রিয়েট হয়ে যায়,
ইন্টারেস্ট ক্রিয়েট হবে।
জাজমেন্ট আছে সঞ্জীব ব্যানার্জির আমাদের।
জাজমেন্ট করে তোরা মুভি
আরে ও
লটা জাজমেন্ট
ভালো ভালো
এখানে এটাও সুপ্রিম কোর্টের জাজমেন্ট আছে অনেক সঞ্জীবের খুব আগে। আমি 20 বছর আগে আলিপুর কোর্টে মামলা করে জিতে এসেছি এই প্রমোটারের এই কেস। ও পাওয়ার ব্যাটনি ক্যান্সেল করে দিল, বলা পরে না না ও নিজেই বলো যে আমি তোমার সঙ্গে আর এই করছি না, পাচ্ছি না, তুমি আমার টার্মস শুনোনি, হেনা দানা ইউনিলেটারে পাওয়ার ব্যাটনি রিভোক করেছে। তো আমরা খালি করে আমি গিয়েছিলাম, তারপরে ওই কেসগুলো দেখেছি।
এখন আর সেটা করতে পারছেন না, এখন রেজিস্ট্রেশনটা
হবে না,
ওয়ান
রেজিস্ট্রেশন হবে
না, এখন তো করতেই পারবে না। এখন ডেভেলপমেন্ট পাওয়ারের সাথে ওটা হচ্ছে ডেভেলপমেন্ট এগ্রিমেন্টের সাথে।
রেজিস্ট্রেশন কেন আটকেছে?
করে হতো বলে ওরা করে দিতে পারতো মালিক,
কন্ট্রাক্ট একটা কথা আছে পজিশন শুরু হয়ে গেছে ওই এই কথা আদারওয়াইজ যদি পাওয়ার ব্যাটনি হোল্ডার মারা যায় আবার করেছেন মানে পাওয়ার ব্যাটনি এই সেম প্রিন্সিপাল মামলা করেছে যে ল্যান্ড ওনার সে কোম্পানি ডিরেক্টর তো পাওয়ার ব্যাটনি ওয়ান অফ দ্য ডিরেক্টর মানে কোম্পানিকে তো পাওয়ার ব্যাটনি সেই কোম্পানি ধরো চেঞ্জ না, যে প্রোডাক্টটা তিনি এক্সিকিউট করলো সে মারা গেল, ইয়েস মনে করতে ল্যান্ড ওনার মারা গেল, তার ছেলে বললো মামলা করে বললো যে আর কোনো ফ্ল্যাট সেল করে বাবার প্রোডাক্ট ছিল, বাবা মারা গেছে, তাহলে পাওয়ার ব্যাটনি সিজ হয়ে গেল আর দাম নেই। ডিরেক্টর যেটা সেল করতে চাইছিল প্রশ্ন হলো যে পাওয়ার ব্যাটনিটা কাকে দিয়েছে? আমরা ডিরেক্টরকে দিয়েছি, ডিরেক্টর যদি চেঞ্জ হয় সেখানে যদি আরেকজন কোম্পানি হিসেবে কাজ হবে
কোম্পানি হিসেবে
তাই তো
কেন ডিরেক্টরও কম পার্সন হিসেবে দাওনি?
হ্যাঁ আমি আর তুমি একটা আমার সরিয়ে দিচ্ছি ওকেও
এক্স ওয়াই জে ডিরেক্টরকে পাওনা বেতন দিতে,
হ্যাঁ
কিন্তু কোম্পানি ডিরেক্টর হিসেবে দিয়েছো নট এজ এ পার্সন, সেখানে পরিষ্কার বারবার লিখে দিই তো কোম্পানি রয়ে যাচ্ছে। নেক্সট ডিরেক্টর
ঠিক সেম ঘটনা ঘটেছিল, ছেলে এসে বলতো যে না আমি পাওয়া পাচ্ছি না, ব্যাংকে গিয়ে আছে সেক্টর কাজ করি কন্ট্রাক্ট
ভাষার আছে
আরেকটা ফানি থিং হচ্ছে
যদি চারটে যাবে
একটু পারবে
তুমি একটা 700 টাকা চারটে তখন পাও কথা বলে গেছে 40,000 জানবে
এই ম্যাটার গুলো সমস্ত হাইকোর্টের কাছে আছে, ঠিক না সুপ্রিম কোর্টে কাজ। সুপ্রিম কোর্টে মে মাসে 2023 কোনো মানে নেই, কোথাও লাস্ট জাজমেন্টটা আব্দুল মতিন দিল
আগে প্রচুর জাজমেন্ট আছে যে পার্ট অফ দি এটা কোনো ইনটেন্ট একটা পার্টিকুলার ল্যাঙ্গুয়েজটা আছে আছে, এটার উপর অনেক জাজমেন্ট আছে আমাদের কেউ কি বলছে যে পার্ট হলেও প্রিএমশন
না, এন্টায়ার হলে প্রিএমশন করা যাবে, পার্ট হলে করা যাবে।
এই সরি বলছি এন্টায়ার হলে প্রিএমশন হবে না, পার্ট
হলে করা যাবে।
এইটা তো
সুপ্রিম কোর্ট বললো যে না এন্টায়ার আছে বলে প্রিএমশন করা যাবে যাবে না। আগের পিছনে জাজমেন্টে বলা আছে হ্যাঁ এখানে কি বললো সেল প্রাইস পুরোটা প্লাস 10% জমা দিতে হবে। এখানে নাম্বারটা ছিল পুরোটা জমা দেয় করা যাবে এই পয়েন্টটা হেল্প করবে।
This is part of the contract.
দুশো দুই তিন চার পার্টিকুলারলি ওই পোর্শনটা বলা আছে 204
তারপরে যদি আমি 203 নিয়ে আমরা মেন রেস্ট্রিকশন
না থার্ড জুলাই আমার দেখতে আগে থার্ড জুলাই
আমার
থার্ড জুলাই But faster. Aim versus a পরে যখন উপস্থিত ওয়ার্ড ইউজ করতে এম করতেন তারপরে
আরেকটা ছিল আরেকটা ছিল
অনেক চিন্তা করছো প্রায়